besides this is obviously going to be this. If you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. Not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Hey, how are you doing, people? I had to play that right at the end because what's going on? 20 odd people. Oh no, actually everyone press a like. Thank you, everybody. I didn't see many people press a like, so I was like, I gotta play my song. How are we, people? Hope you're well. Christine, how are we doing, my darling? Hope you're well. You're probably not here because you always put it up super early, but I'll catch you in a bit, Christine. Patty, good morning, Dylan. How are you, Patty, my darling? Looking forward to listening to you on this trial while I get ready for and get to work this morning. Happy day that you can switch accounts. Hope you're well, my darling. SRA, morning chat. Hey, morning to you as well, SRA. How are you doing this beautiful morning? Kim, how are you, my darling? Nice to see you. I won't call you Kimmy because we normally tell Kimmy to F off. But how are you doing, Kim? Hope you're well. Zach, how are you doing, fella? Hello, everyone. Hope you're doing well today. I'm doing very well, actually. Thank you. Weather's not too bad today, but it's all good. Deb, how are you doing, Deb? Nice to see you. Rhode Island lady. Good morning, Dylan. Good morning to you, Deb. Hope you're well, my darling. Wayne, you changed your name, Wayne. How are you doing, fella? Hope you're well as well, buddy. Hey, hippie chick, Indiana. How are you doing, my darling? Hope you're well as well. Mama Ames. Hello, my lovely. How are you doing, my darling? Hope you're well. Hi, Dylan. Hey, quizzical girl. Good day, mate. How you doing? Putting the shrimp in the barbie. How you doing, Sheila? How you doing, quizzical girl? Hope you're well. Donna, how's the move gone? Good morning, afternoon, Sutherland, and beautiful chat. I hope everyone's day is starting out great. Listening, helping my daughter in. Love. I love that. Get their home in order. Oh, happy days. Happy days. Good luck with that one. Hope the move yesterday was good. Hope, hope that everything went well for the move yesterday. Hope you had a good day there yesterday, but more work today it seems. But it's good. I'm sure your son has left the building. Leave it up to you. I believe it's good afternoon. It's good afternoon. It is, but it's fine. I know what you meant, Mama Ames. It's all good. What's up, Buttercup? How we doing? The Hacksters in the house. Love that. How you doing, my darling? Hey, Karen, subscribe. Hey, you love the music, Karen. How we doing, my lovely? Hope you're well as well. Good morning. Good afternoon. Well, good morning to you. It's good afternoon to me. How are you doing? Jessica, my darling, how are you? How are the boys? Hope they're well. Logan Carter, isn't it? I hope I got that right. But yeah, hope you're well there, Jessica. It was beautiful. I bet you're in charge, so you were telling everyone what to do. So I bet it was beautiful. I want to ask your son and your husband how beautiful they thought it was. I was never called daughter in love. I think you probably called a lot of stuff, Erin Hack. I can imagine all the stuff that they were calling you. But it's all fun and games, though, Erin Hack. I'm sure number one daughter-in-law. Hey Dawn, how are you doing, my darling? Hope you're well as well. Oh, it's nice to see people here. It's lovely to see people in the morning or afternoon for me. Evening for some of you. They'll be watching the replay later. Hey Logan, hello Carter, hello. Make sure you be good to mummy. I'll make sure she gives you some sweets as well. There you go, Erin. You know I love you, Erin. Even though we and Erin got a love-hate relationship. I love her, she hates me, so that's how we work. Kelly, good morning. Good morning to you, Kelly. Good morning, Dylan, everyone. When I logged off yesterday, all I could hear in my head was the jingle to subscribe. I know, I'm sorry. It is quite catchy, though, isn't it? Every time Dana Leonard is here, I always play it. Or if anyone mentions it, I always play it. I love the song. It took me 3 takes to do it. Literally, probably 5 minutes before I went live. I just made it up on the spot. Press the like, press the like, press the like, please. Press the like and subscribe. I won't go into it. But yeah, I enjoy it. I enjoy it. Kay, how are we doing? Hope you're well, my darling. Dawn, Highland Hackers, all do one Kimmy and Granny. Oh yeah, Granny's gone. Granny, bye-bye. Bye-bye, Granny. Hey, cigar. See you, Granny. If you don't know, if you weren't here yesterday, Granny told me in no uncertain terms that she was leaving. She was not coming back here today. So, so I was like, all right, bye, Granny. See you later. Whatever. Don't let the door slam you on the way out. Scrivs, how many witnesses today? Is a state in defense? Yeah, so I think there's 2. It's a bit hard to know. It's either 2 or 3 witnesses left the state to have. 2 big witnesses, long witnesses, and maybe 1 short witness. I'm not sure. But there's definitely 2 witnesses today. Might be 3. I don't know. But they suspect they're going to arrest today. And then it depends if the defense, how many defense have got then for the afternoon, hopefully this morning we're done with the state. And then we'll see how it goes. But just remember, a lot of these witnesses we've seen, they'll be coming back because they're still in the subpoena with the defense, and some of them are with the with the prosecution as well. So yeah, it could get a little bit boring. Maybe we'll see. Haha! Hey Jessica, lots of love to you. Hackster, look at it. Oh, there we go. Thank you, Erin. I was looking for somebody to do that. I thought it might be a Sarah P, but you've done it. Thank you. I'll pin that now. Pin message. Thanks, Erin. It's so catchy. I always sing it. I just love Christmas songs. So, and Dana Leonard loves it. Dana Leonard loves it as well. Oh, he loves it so much. I got to play it again now. Hang on. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. That gave me a chance to get the stream up ready as well. So that was good timing, that was. Is it unmuted? Yes, it is unmuted. That's fine. So there you go. Thanks, Dana, for that. Oh no, I missed Granny. Yeah, Granny came on. She was not impressed with my commentary. She was not impressed. She put me right in my place. So she told me she was going to find another channel to view the trial with. So I was like, okay. It's all good though. If you want to support the Landlord Choir, but always appreciate it, there you go. Those are links to buy me coffee and PayPal. But as Erin says, never required, but always appreciated. And make sure you hit the like and subscribe. You see, it fitted in, didn't it? Just for you, Dana. Now go nibble on some damn lamb. He's never tried lamb. Full stop. You know. That's why I've not had lamb chops for years, but you know. I've had lamb, mutton. Oh, Susanna, Susanna, oh, Susanna, day and night. How you doing, my darling? Hope you're well. Nice to see you again. I've seen you for a very long time, it seems, but lovely to see you, my darling. Thanks for popping in. Good morning, Erin Hack. Morning, all. Oh, have you upset? Who have you upset now? Oh, yesterday. Do you remember yesterday? Granny was there. She was pissed with me, so. Granny was cranky yesterday. She was on one yesterday, Granny was. So I don't think we'll be seeing Granny today. But that's fine. I'm sure another streamer will enjoy her contribution just as much as we did. Morning, Dean and Leonard. Hey, Linda. How we doing, my darling? Hope you're well. Love your channel. Thank you, my darling. I appreciate that. Thank you for the kind commentary. And, you know, I enjoyed yesterday's people. The chat was really good yesterday. It was really, really good yesterday. I did appreciate it. What I love about this channel, and I know maybe it's easier because we're a smaller channel, but everyone's got a different view. Everyone's got a different view. There's some people don't like this judge. I personally love this judge, you know. So, but it's fine if you don't like the judge. It's fine, you know. We'll all have different views as well about guilty, not guilty. Again, that's absolutely fine. There's no reason to get upset about it. I think Granny got a bit upset about my commentary, but you know, it's an opinion. We're all what do they say? Opinions like arseholes. We've all got one. Is that what they say? Yeah, opinions like a bumhole. We've all got one, or something like that. They say, isn't it? There you go, Emma. Oops. Granny hadn't granny panties in a bunch. Hey, Christine, how are we doing, my darling? I did say hello to you as well at the start, but I knew you wouldn't be here right at the start. But I hope you're well, my darling. Brilliant. I think I missed that. Yeah, it was in the afternoon. But whatever. It's all good. Great way not to be cranky is have sex the night before and you'll be in a great mood the following day. There you go, Susanna. We should tell Granny that next time. We should tell Granny that. Love the judge. Think he's ace and makes it nice. I thought he was great yesterday. The way he handled that defense attorney yesterday, put him in his place. I thought that was fantastic. I expected him to shout, no raised voice. That's the way you should do it, in my opinion. I was just so impressed with him. Scrivs, love the way you jumped yesterday suddenly when court restarted, waiting for you to do it today. I'm not looking forward to it. It gives me a fright. It genuinely does give me a fright. I'm a big baby when it comes to these things. I get, I jump over the smallest things. Emma, she wasn't here long, then announced a departure like she was at the fucking airport. I know. Someone just shifted the others. Yes, that's true. Yeah, that's true. Yeah, I hear people's opinions and think, well, that's a shit opinion. But I keep it to myself. I just keep it to myself and go, oh, that's your opinion. You know. Mama Ames, there are plenty of channels to go to. I appreciate the calm way you're approaching the trial. Oh, no worry. Look, don't get me wrong, Mama Ames. There's times where I get upset, or not upset with you guys, but upset with what's going on in the trial, or it really bothers me when people do illegitimate stuff, or I believe is illegitimate, and I will swear, and I will be like, you mofo, I effing hate that. So I will react to it, but it's a genuine reaction. I am not going to react just for the sake of, if I lose my shit, it's because I genuinely feel passionate about something. But other than that, yeah, I just try to keep it calm, keep it, as you would, what you see is what you get. I act the same whether I'm here on TV or if I was on my own. So, you know, so yeah, and not to say I'm perfect because I do get stuff wrong as well, So give me some grace, and which I know you guys will. And it's okay to call me out as well, say I'm wrong. That's fine. I'm not always right. Now, Erin Hack, hey, the judge would love you. When the judge says, spread your legs, Erin, I can imagine you be straight up there. Yeah, I'm spreading. Not for people that weren't here, the judge told the jury yesterday to go and spread their legs rather than go and stretch their legs, which I thought was hilarious. There's a new case that it's a self-defense one. Christy Ricky, I think it is. I had my opinion in the comments this morning. I had my opinion in the comments this morning. Did you? Did I miss that? Yeah, I mean, I think he's a little bit shady at times, the way he does things. And I think I do think the old prosecution are over-objecting as well because of it. As long as he keeps it legitimate, he's doing a good job. He needs to rein it in a little bit, I think. He's pushing the edges a little bit too much, in my opinion. But no, I don't think he's bad. Love the judge. Defense better than prosecution. Still not seen anything convicted. I'm the same as you, Dawn. I'm the same as you. I agree with you. Oops. Steph, good day, mate. Good day, Sheila. How are we, Sheila? Ole, ole, ole. Oh, yeah, you guys say ole, ole. Or what do you say? Oh, Oggy, Oggy, Oggy. Oi, oi, Aussie, Aussie, Aussie. Oi, oi, oi. Aussie, oi. Aussie, oi. Aussie, Aussie, Aussie. Oi, oi, oi. Is that what you say? Erin, ha, ha, ha. Ole, 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 ole. Ole, 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 ole. Erin, ha, ha, ha. Ole, Erin, ha, ha, ha. Ole. There you go, Steph. I played it just for you. Just for you, my darling. Susanna, opinions like arseholes. Everyone has one, exactly. Christy, my darling, how are you? Hope you're well. Oops, what's this message? Okay. Hope you're well, my darling. Nice to see you. Nice. Oops. Crime Junkie, hello to you, my darling. Hope you're feeling better. You're not feeling well yesterday. Hope you're feeling better today. If you're going to work, I hope you have a wonderful day today, Crime Junkie. Carol Draper, good morning to you, my Disney Queen. How are you, my darling? I still love those, like, the years that you always wear. I love them. I'm still back and forth on guilt for this private dancer. Is she a dancer for money? Any old music will do. Look at you. Oi, oi, oi. I'm listening, but you are at work. Fine. Okay, you are at work. Yeah, okay. So hope you feel better, my darling. Hey, Steph. Hey, when Aussies are here, I like to call the land Chapperoo. Placed in today's comments before stream start. Another stream, someone commented how she's ballerina and they can take lots of pain without complaining. Jeepers creepers. I haven't seen that then. That's a bit too much, isn't it? That's a bit too much. Sassy bartender, hello, my darling. How are you do? How are you, my darling? Hope you're well. It's Tina Turner, Trappy. Oh, Tina Turner. I've not listened to Tina Turner for years. Crowd Drugs Delight, still need to talk to you. Got the info from my brother-in-law who is in the FBI. Ooh. Message me. The alternate corner at hotmail.com, I believe it is. We'll get on it, Crime Junkie. I have about 50 pairs of ears, all different themes. Happy days. I just love them. I think they suit you. I just think they suit you. Steph, yeah. Hack. All already. Erin Hack, bloody love that. Your pair of chopper Aussies. Oh, jeepers. Oh, Dennis, really, hang on. Let me play this. We played it yesterday, right? But Dennis sent me another video, right? So hang on. We all saw Dennis's garden yesterday, but he sent me another video. What a beautiful garden. Hang on. It was another video he played me. So let me play it. Because the trial's not started yet, so we can wait. So hang on, people. Please indulge me whilst Dennis Sweeney's in the house. He's got such a beautiful garden. Those that don't know, Dennis is one of the people that the anti-Karen Reid people chucked bleach all over his garden. These are from yesterday. So you can imagine they chucking balloons with bleach on them all over his beautiful garden. So he's had to rework it. You know, pieces of shit. But Dennis is beautiful, my friend. They're beautiful, and I mean, the people, they destroyed his garden. Do you know what I mean? Look at the doggy. Dennis, you're a talented man. There you go. And then the final one here. Look at the horses there. Look at that. So that was what Brenda was saying to me, was that children on the way to school and stuff, they like to touch the ornaments and stuff like that. So you see the ornaments there, but obviously they're full of bleach the other day, so they've had to redo it all again, you know, for the children and stuff. So hey, God bless you, Dennis Sweeney and Brenda Sweeney. Amazing people, amazing people. There you go. That's the end of that. Thanks, Dennis, for sharing that with me, buddy. I appreciate that. You got such a beautiful home. Right. Let me just get the court up. She is, nothing's happening. She just arrived. Hang on then. Let's get through this quickly then. Sassy, Chopper Aussies, Dennis, Puppy, Dana, hope you're well. Good morning, Terry. How are we doing, Terry Martins? I admire anyone who can grow things. I kill plants of any kind. Magical garden, then. It is. How gorgeous. Thank you. Me as well. I know. I'm gorgeous as well. I know. Thank you, Jessica. Other chants are very, very on the side of the ballerina. I still want to see you pirouette for proof. Good morning, Proof and Appropriate. Hope you're doing well, my darling. Hope you're okay. Nice to see you. Nice to see you here. Beautiful. Thank you. And also towards Dennis. Dennis, beautiful, gorgeous garden, my friend. Those scumbars are gross, yeah. We got no quit. Nothing will stop me. I know, but also you're not allowed to quit, Dennis, because Brenda's there. So let's be honest. Even if you wanted to quit, Brenda won't let you anyway. So behind every great man is even a greater woman. So that's Brenda. You have a German Shepherd, Dennis. If your veggie garden got destroyed, I have much to give from mine. If you and Brenda would like, he's love the Swedies.
Testing.
Do you go all out decorated Christmas time, Dennis? I could see you guys being the type to be on the All American Light Show. Yeah, I can imagine that as well. Especially they do all that for the local children and stuff like that. Rebecca, hello, my darling, in West Virginia. Daughter Eva of deceased popped up on my TikTok last night. Seems to have good supportive friends. There you go. Wrong trial, isn't that Karen's trial, lol. Oops. Hugs to you, Brenda Dennis. Dennis, how often do you have to mow the grass? As often as Brenda tells him. Probably every week, isn't it? Right. Court. Oh, I should say court is in session. Oh, no. Oops, wrong one. The court is on mute, people, before anyone starts shouting. Erin Hakkakirk. Court is. Okay. We'll see what this comes up as today then. So yeah, definitely 2 witnesses today, maybe 3. Hey Lou! Lou. I just made it, was getting little Archie to sleep. Oh, little Archie, sweet little Archie. Hope he's well, my darling. Hope he's well. Eva's some cool t-shirts on our website, ghostcowboy.co. She seems to watch trials, has justice for Johnny and 3 Young Thug t-shirts.
All right, State, well, you continue to test that.
Hey,
Good morning, everybody. We're back on the record in State versus Ashley Benefield. 2020 CF 3014. Present is Miss O'Donnell. Miss Field. Present is Mr. Taylor and Miss Benefield. Couple of matters before we get started. Yesterday, I had brought up that an anonymous reporter had come up to the 9th floor and spoken with the deputy who's there at the desk with some sort of information. This morning, 5 minutes ago, I was provided a letter from a law firm in West Palm Beach dated yesterday. It says that it was sent to the state and the defense. Did you each get a copy, State?
Yes.
I did, and I responded late last evening, Your Honor, and a copy of Your Honor's chambers as well as Suzanne.
Yes.
Oh, I don't have those responses.
He just said, thank you for sending it. I said I didn't get an attachment and realized I was looking at the wrong email.
I thanked him. I told him it was worthy of calling it to the court's attention and that I was confident Your Honor would probably conduct a hearing as a result.
That's what I'm doing. Do you want to be heard on this, State?
No.
Defense? Do you want to be heard on this?
Yes, I'd like the court to question the jurors individually. I don't know, like the lawyer said, whether or not the potential juror heard it. I have every confidence the court can do it delicately and first find out if which juror, if any, was exposed to that, and then find out if they heard anything that had any impact at all on their perception of the case, and that was extrajudicial in the sense that it was a reference to something that had not been introduced in the court.
All jurors or just male jurors?
Judge, I would suggest respectfully all the jurors, and I think.
Even though the letter says it was a male juror?
Yes, because that's what this anonymous source said. But I think to be safe, to the extent there was some jurors in this location, there's limited places to go for lunch around here, Judge, so I think there's potential that there could have been other jurors there as well. And rather than run the risk of not knowing, I think a simple inquiry by Your Honor would put that to rest.
State?
And Judge, I would just recommend that maybe we ask the group these general questions, and if anybody says that they've heard anything or seen any news or heard you talking, then we can talk to them individually, because these people may not have had any information. And then we'll spend time doing individual on it.
The concern with that is, in my experience, respectfully, any juror that was exposed to that may be very anxious about acknowledging it.
All right, thank you. I'll bring them in individually to ask about that. Of course, we've already discussed Dr. Quintel when we came back from a recess. He was approached by a reporter in the hallway while he was in the middle of testifying, but on a recess, asked if he could be, the reporter asked if he could ask questions of Dr. Quintel. Dr. Quintel said no, and the reporter gave him a card. That's my understanding from Dr. Quintel.
Yes, sir.
Anybody want to be heard on that?
Did not take it. The card.
Do you want to be heard on that?
Sorry, I just wanted to add that Dr.
All right.
Quintel
Do you want to be heard on it, though?
No.
No.
After hours yesterday, I was contacted by Judicial Security and notified that a witness who testified and had not been released from subpoena, and again, this is second or third hand, it's my understanding both parties have been made aware of this, was being interviewed by a news channel reporter in the hallway outside of the courtroom. When deputies were locking up, someone told them that this was going on. I don't think the deputies actually saw it, but it was reported to them.
And Judge, I spoke to the witness and there was a discussion with the media, but nothing was talked about what was going on in the trial or testimony or anything like that. And I've spoken with the witness and asked them not to do that anymore before the trial's over.
This is the first I've heard of that, Your Honor. I wanted to know who the witness was.
The reason I didn't speak in specifics is this is all hearsay within hearsay within hearsay.
I understand.
It was reported that it was Eva Benefield gave an interview to a reporter from News Channel 8.
Give me a moment, Your Honor, please. I believe she's under state subpoena.
Yes.
And did the state request that she remain available under the subpoena?
Yes.
Okay. I think perhaps a hearing may be in order.
All right.
And the state would not be opposed to a hearing. I can represent that this particular witness did not speak about anything that was prohibited by the rule of sequestration. No one said to this witness, you're not allowed to talk to anybody about the case, just your testimony and the witnesses in this trial going on right now. So.
All right. Go ahead.
So, not to compound it, but to the extent we're doing housekeeping things now, we also have an issue, Your Honor, with an impeachment witness to Stephanie Murphy, specifically Faith Brown, who is representing Miss Benefield during the same proceedings. She was not on our witness list, but given the testimony of Miss Murphy, we are going to have her outside this afternoon, and the court may want to conduct a Richardson hearing as to that. So just for planning purposes.
All right. Do you understand that Faith Brown may be called as a witness?
Yes.
All right. I wasn't going to get too involved in the Richardson hearing yet. It needs to be done, obviously, and I've got a note for that. All right. So on the Eva Benefield potential interview with someone at News Channel 8, you're not asking for any relief.
No.
I don't know what relief you're going to ask for, but if you're asking for some relief, I'll let you get started.
Well, the relief I would ask for initially is that she obviously be barred from being called as a witness potentially. Secondarily, to the extent the court admonished her about doing exactly that which she did, I've observed thus far the court's general admonishment that it gives to witnesses. I'm assuming Benefield received it as well. Is she in the courtroom, by the way? Ms. Benefield?
Here she is, yes.
I'd like to have her step out.
All right, ma'am, if you please remove yourself from the courtroom.
This is a young girl who lost a father. I'm not looking to hurt her, but given her disregard of the court's admonition, I think precluding her from being called as a rebuttal witness at a minimum would be appropriate. Whether or not the court feels any further sanctions are appropriate as a result of her disregard of the court's warning, I defer to you all.
Did you want to be heard at all?
Judge, I would just dispute that she violated exactly the court's order. And if she does testify, she will testify consistently with what she has already testified to in a deposition. So counsel will know if that changes, but we know what she's going to say because she said things already in the deposition. So I don't think any potential harm has come from it.
Rebuttal. All right. Whenever we talk about having a hearing, my assumption at the beginning of that was that it was going to be evidentiary and people were going to call witnesses and present evidence. Here's what the court knows. Someone told a court deputy that they observed Eva Benefield giving an interview to News Channel 8 reporter in the hallway outside of courtroom A after court had concluded for the day. At this point, I have no facts or evidence before me. I've got hearsay within hearsay as to something that happened.
All right, Judge.
Yeah, so I don't.
I'll call her.
Well, I gave you that opportunity. That's what I'm saying is that if everybody wanted a hearing, then.
All right, well, I took it for granted that the court would.
I'm not going to assume this is true.
Yeah, so court likes, I'll be happy to call her and we'll have a brief hearing.
It's up to you. All right, can you call Miss Benefield back in?
Oh, people. Hey, Elisa. It's all going off this morning, people.
Steve, just looking at the list, you have 3 witnesses left? All right. Do we expect to finish today with the state's case?
So we got this witness
Come on
now.
in, man.
We've got the jury to come in one by one. Just wait, people. There's more.
Do we know which deputy reported the matter?
No.
Or any of the deputies in the courtroom that saw the conversation like yesterday afternoon? Do we know which deputy it was?
As I said, it was reported to me that some unidentified person told the deputy.
Okay, so give me just one moment.
Are you the one that they told? Yeah. Okay, right here. Mr. Taylor.
Got it.
Apparently it was reported to Deputy Racky.
I have a moment with the deputy.
Of course, State, you want to be present?
So basically,
Just have to step into our office.
so what's happened, right? So basically, I'll mute this for a second. Is Eva, the daughter, spoke to news cameras last night. I don't know how much she said, whatever she said. She was not supposed to do that, blah, blah, blah. Fine. Also, what you missed at the start was the jury are going to be called in one by one as well, because it was reported that the juror has been given some information, or may have overheard some information about the trial, and they shouldn't have done it. So if you remember the journalist yesterday, oh, hang on, just in case they're back.
Ms. Benefield, I'll remind you that you are under oath. You can scoot a little bit closer to that microphone and just answer the questions in a loud, clear voice.
Good morning, Ms. Benefield.
Good morning.
You appeared yesterday and testified before Judge White in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. Time flies. At the end of your testimony, do you recall Judge White instructing you about having contact with anyone because you were to remain under subpoena? Do you recall that?
I recall.
Okay. And you are here today because the state requested that you remain as a potential rebuttal witness.
Correct.
Now, what did you think Judge White's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
Did you realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us, if you would. I'm just trying to get an explanation. Tell us, if you would, what you were thinking that.
Objection.
Overruled.
That's not what she said.
What you were thinking that you felt allowed you to do exactly that which Judge White cautioned you not to.
I was caught off guard in the hallway when I was under extreme emotional distress after being here, hearing different testimonies about my father's murder. And when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you discuss with the reporter?
Just how I felt about the situation and who my dad's character was as I saw him.
When you say about the situation, you mean about the case, the trial?
Not about the trial.
What situation were you referring to?
My emotional state.
Okay. You post on social media,
I do.
TikTok,
Yes.
any others?
No.
Following your testimony here last Tuesday, did you make any posts?
I did.
Tell us how many?
3.
3. And tell us one at a time. Were all 3 of them on Tuesday afternoon, Tuesday evening?
1 was on Tuesday.
And when were the other 2?
Yesterday.
Okay. And tell us, as to the first post, what was it about?
I said that I testified.
Okay. And did you have anything to say about your testifying?
I talked about it being on live television,
Mm-hmm. What else?
that somebody back home was watching.
I assume you have copies on your phone?
I do.
You have your phone with you here today?
I do not. Not on me.
Where is it?
It's over in the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
Yes, sir.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Judge, I'm going to object if he knows clearly they have the post. So
Well, I don't know.
it's an invasion of her privacy to dig into her phone.
Not if it's on social media, but we started off talking about just speaking with some reporter, and now we're talking about a social media post. If you've seen it and if she's violating the rules, let's just get it out.
Okay. I'm trying to find that out.
So now it's a fishing expedition.
What's
If you know a violation, let's talk about it. If not, let's just get moving. We got jury waiting.
I understand that, Judge. How do I know? She's told us she posted 3 things. How do I know what it's about? What if one of them involved discussions that were inappropriate? How am I to know that? I've been a little preoccupied, and I don't do social media.
Sir, if you have specific evidence, let's talk about it. If not, you have a team. You've got Mr. 1, 2, 3 people in court right behind you. I don't know, maybe they can look it up, but let's focus on what we know about as opposed to digging into speculation.
I have no further questions.
No questions.
Ms. Benefield, when you had this conversation with the reporter in the hallway, were there any other witnesses around?
Yes. I'm sorry. Let me re-answer that question. None that testified. I think.
Okay, so you're saying there were people standing
There
around,
were people
but
around.
none of the witnesses in this case?
No, sir. Not that I remember.
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
All right. Do you have any follow-up questions to my questions?
No, sir.
Do you have any follow-up questions to my questions? All right, Ms. Benefield, you can step back out. Did you want to call any other witnesses?
No, sir.
State?
No.
All right. All right, Ms. Benefield's out of the courtroom. Go ahead, sir. Do you have any argument? You want to seek any relief? You want to argue in support of any relief?
Yeah, I think she violated the court's admonition that the court routinely gives to the witnesses. And as a result, again, I have no personal interest in seeing the young woman suffer, but I do think violation of the court's admonition is sufficient to strike her as a potential rebuttal witness.
Judge, I think you asked for the relevant questions. I think the questions that you asked her are the admonitions that you gave her as a witness, and she did not break any of those.
Final thoughts? I'm certainly distressed that, let me say first, the media policy for the 12th Circuit prohibits the media from conducting interviews inside of the courthouse. It is my understanding that our media and public relations person met this morning or was going to meet this morning with the media to go over the administrative order again, because certainly I think the media is and should be aware of that administrative order and comply with it. The specific incident that we're talking about after hours yesterday, the facts that are in front of me are not that Ms. Benefield spoke about her testimony or the questions asked. But I also have not heard from the reporter, and I have not seen any tape or footage. At this point, I'm going to reserve on the request, and I'll make a decision. If and when she's called again, I'll make a decision at that point. You just have to remind me if we get there.
I'm satisfied, Your Honor. Thank you.
All right, next. Deputy, if you just start, I don't care about the order, just start bringing in the jurors one at a time, please.
Judges, Ms. Beckman, allowed back and forth. And Marks as well.
Yes. Yes, but I'm going to give her an admonition. And just, if you tell him to just hold up for a second, she can come back in. At this point, I'm reserving on whether she can be recalled or not, but I think an admonition at this point is appropriate. Yes, Ms. Benefield can come in.
This court going to allow her to sit in for the testimony, knowing that she may be recalled. That rule has been invoked.
Yes, under Marcy's. Sorry. No, hold on. All right, Ms. Benefield, you can stop right there. Ma'am, the court has ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given and the importance of those. They matter and they need to be followed. Do you understand?
Yes, sir.
All right, ma'am, you can retake your seat. All right. No.
I think she's gone out because she's upset, I think. So. Wow, now we're going to get the jurors in one by one. So just a reminder, the journalist yesterday who wanted to meet the judge instead went to an attorney last night. They filed a letter to the judge and the lawyers to say that they'd heard that a witness had come into touch
Morning,
with.
sir. You can just grab this front chair, it's just fine.
You'll find out now.
And can you remind me, please, what juror number you were?
33.
33. All right. Juror 33, the reason I'm going to bring the jurors out individually is that this morning the court was provided a letter from a law firm representing a reporter who indicated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing you out to find out, did that happen to you? Have you received any information outside of these 4 walls?
No, I didn't go to a restaurant. I was actually I was in my car here in this building.
All right. State, do you have any questions?
No, thank you.
Defense?
No, sir.
All right, thank you, sir. Good morning, ma'am. Just grab that first chair. And could you please remind me which juror number you were?
15.
15. All right, ma'am. The reason I'm bringing about jurors individually is that this morning I was provided a letter from a law firm in West Palm Beach that claims to represent a news reporter. And the news reporter anonymously has stated that during the lunch break yesterday, the reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to talk about, have you seen any news coverage? Have you heard people discussing the case? Received anything outside of this room?
No, sir, I go home at lunch.
State, do you have any questions?
No, sir.
Defense?
No, sir.
Thank you, ma'am. Good morning. Just have a seat right there. And could you do me a favor and remind me of your juror number?
20.
Ma'am, the reason I'm calling out the jurors individually is because this morning I received an email, a letter from a law firm in West Palm Beach who claims to represent a reporter. And the reporter has anonymously stated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm asking everybody,
Are you familiar with that? Has that happened to you? Have you received any information outside of these four walls?
No, I have not.
State, any questions? Defense?
No, sir.
Thank you, ma'am. All right, good morning. Have a seat right there. That's fine. Could you remind me of your juror number?
Originally 42.
42. Thank you. All right, ma'am. The reason I'm calling out the jurors individually is because this morning I was given a letter from a law firm in West Palm Beach who claims to represent an anonymous reporter. And the letter says, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out is just to say, are you familiar with this? Have you heard of this? Have you been approached by anybody? Have you watched anything on TV? Anything at all?
No, Judge. Yesterday, a couple of us chose to just not go to the restaurant area, and simply because we saw some people out and about, and we just figured it would be best to just stay clear of all of that. And no, I have not watched or viewed anything on media.
Thank you. State?
No questions, Judge.
Defense? None. Thank you, ma'am. Good morning. Just have a seat right there. That'll be just fine. And ma'am, could you remind me of your juror number from Monday?
35.
All right, thank you very much. Ma'am, the reason I'm calling the jurors out individually is because this morning I was provided a letter from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And here's what the letter says, essentially. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with this? Did you see any of this? Have you done anything to look at or hear anything outside of this courtroom?
I have not.
All right. State?
No questions.
No question.
All right. Thank you, ma'am. All right, ma'am. Have a seat. And could you please remind me of your juror number?
Just from the day when I was here on Monday.
Yes.
Number 21, I believe.
All right, thank you so much. All right, ma'am, the reason I'm talking to each of the jurors individually is because I received a letter this morning from a law firm in West Palm Beach. And they claim to represent an anonymous reporter. And what the letter says is during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, two individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to say, are you familiar with that? Do you know anything about it? Or have you looked at anything outside of these four walls during this trial?
No, I'm not aware. The only situation I do know, one of the jurors, Ted, I believe mentioned he was out to lunch. And he mentioned that he did get it. He got up and left a restaurant. But that's all he mentioned. He said he felt uncomfortable and left.
Thank you, ma'am. State.
No
Oh, hold on.
I'm sorry.
No, you're fine. They just like in trial, they get a chance to ask their questions too.
Yes, no
Okay?
questions, Judge.
No question. All right, thank you, ma'am. All right, good morning, ma'am.
Good morning.
Could you please remind me of your juror number
My original one or here?
originally?
29.
All right, thank you. Ma'am, the reason I'm bringing everybody in individually from the jury is because this morning I received a letter from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter says. During lunch on yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I bring everybody out is to say, do you know anything about this? Have you heard anything about this? And also, have you viewed or seen anything outside of this courtroom?
No, I haven't. And I brought my lunch yesterday and ate downstairs on the table.
State?
No questions.
No question.
All right, thank you, ma'am. All right. Hello, sir. Can you please remind me of your juror number for Monday?
43.
Thank you, sir. The reason I'm bringing all the jurors out individually is because I received a letter this morning from a law firm in West Palm Beach, and they claim to represent an anonymous reporter. And here's what the letter essentially says. During the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm calling everybody out individually to say, do you know anything about this? Are you aware of this situation? And also, have you been following the court's admonitions? Have you been influenced? Have you seen anything outside of these 4 walls?
Yes, Your Honor, that was me at the restaurant. I was getting my lunch to go, and I was keeping everything out of my view and wasn't looking at anything on the news. And I left immediately because I felt uncomfortable, and I haven't gone back to the restaurant. That's what I did. I ate my lunch in the park right out in front of the courthouse.
All right, sir. So when you said you weren't paying attention, was that to the television?
That's correct. I was not in the view of the television at all, and I asked the business owner to pack my lunch to go so I could leave.
And did you overhear 2 individuals in that restaurant discussing a witness's testimony?
I did not.
State?
No questions.
No question.
Thank you, sir. All right. Hello, ma'am. Can you please remind me of your juror number from Monday?
38.
38. Thank you.
What was the number, Judge?
38.
Thank you.
Ma'am, here's why I'm calling everybody out individually. This morning, I received a letter from a law firm in West Palm Beach, and I want to talk to everybody individually. And they claim to represent an anonymous reporter. And the letter says, essentially, during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So the reason I'm calling everybody out individually is just to say, do you know anything about this? Have you heard anything about this? And have you seen any news or anything outside of these 4 walls about this case? State?
No questions.
No?
No questions.
Defense?
No question.
All right, thank you, ma'am. All right, the jury's out. State, do you want to be heard on this issue? Defense?
No.
All right, the letter that I received from the law firm is going to be filed in the court file.
Two at the same restaurant and had some knowledge confirming his story.
Confirming his story. Okay.
He requested the TV be turned off.
That he requested it.
Yes, sir.
Okay. The deputy has informed me that somebody in the audience was at the same restaurant. And again, this is hearsay within hearsay. Would confirm that the juror asked for the television to be turned off.
Yes,
Does anybody want me to find out who that is and have them brought forward? State?
Give me just a moment. No, you're right.
All right. So is there anything else we need to take up before we get started with today's case?
Not from the state.
Not from the effect.
Okay. All right, let's go ahead and bring the jury in.
Sea Dog, that's not her mother, that's her stepmother. And she hates the stepmother, no, not supportive at all of the stepmother. Stepmother, she's 32 now, the daughter is 23, 24. She got married to the daughter's father, and she was 24, and the father was 57, something like that. There's a 30-year difference, age gap. So. Dave, you just allegedly a juror may have overheard some people talking the case during lunch break, but they're not doing anything with it. I agree with everybody that says they should provide lunch. I agree.
Or y'all can have a seat. Welcome back, everybody, as a group again. Just need to confirm that I kind of talked about this individually just a moment ago, but that no one has talked amongst yourselves about the case or began your deliberations. No one's talked with anybody outside of the jury about this case, and no one has done any research on the people, places, things, or legal topics we've heard anything about. All right, everybody says no. When we left off yesterday, the state was still presenting its case. State, call your next witness.
State Hall Sergeant Brian Quiles.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Hello, sir. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. There you go. And if you just speak in a loud, clear voice right into it, it should be just fine. If we hear you breathing, you're too close.
Okay.
Good morning.
Good morning.
Please state your name and spell your first and last name.
Brian Quiles, BrianQuiles.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
About 19 and a half years.
What is your current position with them?
I'm the supervisor of the technical services unit.
And you're, I don't know if I said this, you're a sergeant?
Yes.
Okay. And what is the technical services unit?
It's a unit that gets involved in the technical aspects of criminal investigations. One of the responsibilities is downloading data from cell phones and analyzing that data.
Okay. And prior to your current position, what positions did you have at the sheriff's office?
Several. I started on the road, moved over to a cops unit, eventually moved over to the Special Investigations Division as an undercover detective for a couple of years. After that, there was a position involved in, again, technical aspects of investigations. It just wasn't called the Technical Services Unit at the time. And that's until I did that position for a number of years until I was promoted, and eventually the Technical Services Unit started, and that's when I started supervising that unit.
And what training and education do you have to do your current position?
I've had probably over around 800 hours of various technical training, some related to cell phones, some related to technical surveillance, but roughly 800 hours of total training.
Okay. And I want to talk about specifically cell phones and how you deal with those. So how much training would you say you've had in cell phones and analyzing cell phones?
It's probably a third of that 800. So around 250, 260, something like that.
Okay. When you do what I call a forensic examination of a phone, what do you do? Just briefly.
It's really a case-by-case basis. There's each phone, it's somewhat of a research project. There's so many variables, but ultimately that phone will get plugged into a forensic workstation. Software would be used to be able to download or extract that data from that cell phone. And that same forensic workstation will use software to be able to decode or parse that data to be able to review it.
When you download, I call it dump, a cell phone, when you dump the information from a cell phone, is it voluminous?
Yeah, it can be. Yes, it's quite a bit.
Okay. And is it easy to interpret without help?
No, you definitely need a certain expertise to be able to look at it. You need software to make it a little bit more of a convenience to be able to look at it, but definitely need some assistance to be able to do it.
And do you have programs, software that helps you with that?
Yes.
What are the names of the ones you use?
Our main state program is Cellbrite. It helps us extract the data. If it needs to bypass encryption and bypass locks, it'll help us do that as well. There's other programs that we use, Gray Shift, excuse me, as well, to be able to unlock the data and extract it. We have toolkits that I like to refer to of data or of software to be able to use.
And give me a general idea of how many phones you've done this with.
Me personally, hundreds. I want to say the unit as a whole has steadily done 200 to 300 leading up to about 2002, and that has increased probably closer to about 500 devices for this year alone, I'm pretty sure.
Okay, so the unit 500 devices for this year.
Yes.
And when you use software like Cellbrite or Gray
Shift,
does it allow you to put whatever data you want, for instance, pick out what you want and put it in an easily readable form?
You can filter the reports that the software displays, and if you only want it to include messages, you can create a report with just those messages. Sure.
So, for instance, on just your average cell phone, if you did a cell phone dump, you would get messages like text messages.
Yes.
And emails.
Yes.
Internet searches.
Yes.
And all different things that would be on your phone.
If those data transactions exist on the phone, you will typically get those. Yes.
Okay. So this software allows you to pare that down to what you want.
Yes.
In the instant case where you asked to do extractions on 2 phones.
Yes.
Okay. And I'm going to show you what's been previously entered into evidence as States Exhibit 11 and 12. You can take a look at both of those. Can you tell me what those are?
These are the 2 cell phones that I had done examinations on. One of them belonging to Doug Benefield, the other one belonging to Ashley Benefield.
And is that the evidence tag that's on there, do you recognize that?
Yes.
And does it have your information on it?
Yes, it does.
Okay. So did you go through the process that you just explained with both of these phones?
There were differences in the process, but ultimately we were able to get a path to data and produce a report for that data.
Okay. And which one were you able to extract first?
Doug's phone, we were able to extract first.
Okay. And then were you able to extract data from Ashley's phone?
We were able to eventually. It did take quite some time.
Okay. Why did it take quite some time?
That phone, it was passcoded, or it had a PIN code. I want to say it was a 6-digit PIN code, and the software, it took a long time to actually bypass that encryption or that PIN.
Okay, so if you don't have the passcode or a way to get into the phone, your system can do that?
Yes, it varies in length of how long it could take to bypass, but yes, the system allows for that.
Okay, and you called one of those Doug's phone and one of those Ashley's phone. When you do extractions of the data, do you get information about identifying who owns the phone?
Yes.
And can you just explain what that is?
Yeah, a lot of the times, especially with iPhones, you'll have an Apple ID that could be associated with the person that owns a phone. In the contact information, it'll have the owner's information, so it's pretty easily identify who that phone belongs to, especially with iPhones.
Okay, and the one phone, I'm not sure if it's 11 or 12, that you said was Doug's phone.
12.
12. Did that have identifying information on it?
Yes.
That identified it as Doug's phone?
Correct.
And then for Ashley's phone, same question?
Yes.
Did you prepare a spreadsheet for this case?
I did.
And what is on the spreadsheet?
It was communication between Ashley and Doug extracted from Ashley's phone from September 20th of 2020 until September 27th of 2020.
Okay. And when you say communication, what do you mean?
In that particular report, it was mainly text messaging back and forth. There were a few phone calls and I want to say at least one email, but mostly text messages.
Okay. And you said you prepared the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare that information was on his phone as well?
Yes.
Okay. And was it?
Yes.
I'm going to show you what's been marked as States Exhibit 98. You can tell me if you recognize that.
I do.
And what is it?
This is the CD containing the Excel spreadsheet that we just talked about.
Okay. And when you said there's communications between the two, if there were any attachments to those communications, would they also be in your spreadsheet?
Yes, they would. Yes.
Okay. And you looked at this?
Yes.
Yes. And is it accurate based on the spreadsheet that you created?
Yes.
Statement of evidence states 98.
Any objection to States Exhibit 98?
No.
Received.
So I'm going to publish the spreadsheet now. If we could turn down the lights and potentially, it's a little difficult to read, potentially shut the blinds. Okay, so I know this is very small, at least from where I'm sitting. I don't know if I have handed you an exact copy, a hard copy. So I don't know what is easier for you to read. I know that print is very small as well. Sure.
Okay, so we'll see. Hello, Wendy. Wendy, by the way, nice to see you, my darling. Not seen you for a while now, so lovely to see you, my darling. Yeah, this still. I hope we can see it. I hope it's clear enough so we can see what's being said. But not that we will probably understand what's being said. But hey, Gitmo, I didn't see you sneak in there. And hello to everybody that I may have missed when you snuck in and didn't know you were here. again, thank you to Alice and Miles for the super sticker and also for becoming a new member as well. Where you from, Alison? Because that's UK. That's pounds. Where you from, Alison? If you're still here, whereabouts in the UK you from? Hey, Raoul. Wendy H. Hey, the beautiful from Josie. Wendy Hey, hello, my friend. Carol, the only thing I would say is possibly that her lawyers told her not to pass it over. Because her lawyer at the time did tell her not to speak to the police, not to say anything, not to do anything, and probably told her not to give over her PIN. Which is quite normal for defense to say that. But yesterday it was confirmed that, the attorney said, the attorneys did say do not speak at all with them. So that's why I probably imagine it is. Right, here he is. Hamburger's got the flowers out for Wendy. We know it's not Wales. You shut it, Hackster, with your Wisconsin. Okay, Abernethy, just aside Perth. Okay, I know where you. Well, I don't know where you are, but sweet. That's good. I love Scotland. I lived in Glasgow for a year. I absolutely adore Scotland. I think similar to Wales, just gorgeous. But welcome, Alison. Nice to see you, darling. Gitbo, I've been watching from behind the bushes. You're in there with Erin Hackland. She's in the bushes somewhere, in the weeds there somewhere as well. Just mind yourself. There'll be a big yellow bus there somewhere with Erin Hack driving through the weeds with you. I wouldn't give them a thing. Yeah, get search water one. I know. I was just pretending because of your accent. Wisconsin, Minnesota with the tubes. Erin Hack, 4'1", in the weeds. Hurt, Wisconsin. Go Pack Go, Dave. Go Pack Go. Just a reminder, we got 3 witnesses today. This one and 2 others, and then a state arresting. Let's get through them all today, hopefully. Aaron, he's losing it, needs vacation. Hey, Lou! Gorgeous. It is. Yeah, I do, Steph. Yeah.
Are you going to read from the one in front of you or the one behind you?
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through what we're looking at. So I have a laser pointer for you. So the red button is yours. And I have one as well. I do want to talk a little bit about these attachments that are on the phone or on this spreadsheet. Are you able to tell when you look at one of these attachments where that image or picture or video came from?
It depends on each attachment. There could be metadata there that the attachment could have been from a screenshot. It could have been from the actual phone, taken with the actual phone. So it just, again, case by case basis.
Okay. So there is a video on this phone that, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about?
I'm not, no.
Let me, hold on one moment and I'll let you know which one it is.
Hello, everybody. Hail, Mike and stuff. That's a good question as well, Steph. Yeah, I am Welsh speaker. I don't speak English at all. Well, very rarely. Only online I speak English. So that's why I struggle sometimes with some words. And She's like a big sister, always give me rounds, Erin Hack is.
It's line number 25
Gigi, hello.
on your spreadsheet. Can you tell from what you're looking at where that video came from? Or do you recall from your investigation before where that video came from?
And based on what I'm looking at, it's an attachment from a text message from Doug Benefield to Miss Benefield.
Okay. And when you looked at Doug Benefield's phone, could you tell whether this movie was taken on his phone or sent to his phone?
I don't have a recollection of the actual metadata of the video itself on either phone. This is just looking at it from the attachment perspective, not the specific video itself.
Okay. If we could approach, Judge.
Oh, what's going on? What's going on? Your English. Thank you, Chrissy. That's so cool. I don't know a lot about Wales, but I've seen in recent years a push for learning the Welsh language. Yes, can't wait to keep picking your brain. Yeah, it's massive. Welsh language started to become a big thing here. Don't know if you are predominantly Welsh speaking. Is there a large amount of speakers in your area or just your friends? Where I live, it's mostly Welsh. Welsh speaking. Pretty much every store, shop that I go into is Welsh speaking. So, yeah.
Okay, so let me hook this back up. And let's talk about what we're looking at first, and then I can try and make this a little bigger so people can see it. All right, so the first column just has the number of the entry, correct?
Correct.
Okay, and the second column is what?
It's just the type of entry it is.
And give me a couple of examples of the type of entry that it is into the phone.
In this timeline, it's labeled as an instant message. If it was a phone call, you would see phone call. If it was an email, you would see email.
Okay. And what does instant message mean? Is that a text?
It's a text.
Okay. And then the third column is what?
It's the direction of that transaction. It's specifically dealing with messages, whether it's incoming or outgoing.
Okay. So that would be incoming or outgoing from Ashley Benefield's phone.
Correct.
All right. And then the next column?
It's whether or not that data transaction has an attachment.
Okay. And then the next column?
It's the date.
And the next?
It says time, but it also has the date and the time in the correct time code and time zone.
Okay. You said correct time zone. Can you explain that real quick?
So if you see UTC -4, UTC is what's considered standard time for world clocks. The time where the prime meridian is in the world, you subtract from that and you come up with a time code or the time zone that you're in. We are currently in -4. We're technically -5, but because daylight savings times, we actually subtract -4.
Okay. So does your software do that automatically?
Yes.
Okay. So when it says at the first line, it says 8:20.02, and that says UTC -4, that is the current Florida Bradenton time.
Correct.
Okay. And then the next column. And I made it bigger on the screen if it's easier for you to see.
I can see it
Okay.
fine here. The party is the people that are a part of the actual message.
Okay. And are these the labels, the names that are entered into Ashley Benefield's phone?
Correct.
Okay. And the next column?
The description will, in this case, the first one is blank, but ultimately will have the body of a text message. Sometimes it'll be empty depending on the nature of it, but that's where the body of the text message would be.
Okay. So the next column.
The source is just the software's way of saying if it was a native message or if it was taken with a third-party application.
Okay. And the next column.
The attachment is the actual file itself and the file name.
And then the last column.
The source file information has a lot of metadata where that file actually exists and the file paths and the size. And if you look at the table, all this information comes from databases, and it explains where or what table the database that this message or this data lies.
Okay. So let me move it back over. So after we get through this explanation, we'll move much faster. But the first message is what? If you could just explain to us what that is.
Item number 1 is listed as a message. It's an incoming message with an attachment, and appears there's no body to it. In other words, there's no actually text string. It's just the actual attachment itself.
And who is it from and who is it to?
It's from Doug to, I'm just going to say the name that's on the actual.
That's fine.
It says Ashley Christina.
Okay. And is this the attachment?
Yes.
Okay. And if you could just read for the record what that says.
Says, am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bondservant of Christ.
Okay. And then the next message is what?
Number 2 appears to be an outgoing message. It's from Ashley Christina to Doug Benefield.
And how much later than the first message is that?
About 2 hours, it appears.
Okay. And so from Ashley to Doug, and what is it?
The description says loved an image.
Okay. So she loved the image from before.
Correct. That's more of an action than actual writing something out.
Okay. Yes. She didn't type loved image.
No.
The phone is saying that she hit some button.
Correct.
To love the image. All right. And then the next message is from right about the same time. And that says what?
Same time, that says good morning. There's another little icon after it, but it just didn't come out on here.
Okay. And then if you could just continue to read.
The next message, number 4?
Right, the next message. Okay. If you can just say what time.
Okay.
To and from, and then what the message is.
So the next message sent around the same time, 10:36 a.m. It's from Doug to Ashley Christina. It says good morning with a few emojis. Then the next message after that, appears to be an attachment, and that's at 11:43 from Doug to Ashley Christina.
And what is the message right after that? Oh, I just went too far. Right after the attachment, I'm sorry.
Right after the attachment?
Yes.
It would be number 6. It's a message at 9:20, 11:43 from Doug to Ashley, and it says run baby run with a few emojis.
Okay. And so now I'll just play the attachment.
Run, baby. Run, baby.
Okay. So Doug says run baby run to Ashley, and then what does she do?
That would be number 7. It's a instant message right after. It's at 12:16, and it just says laughed at a movie.
Okay. And if you can just keep reading.
Number 8 would be an outgoing message. It's from Ashley to Doug. It's on the same date at 12:16 p.m. It's just a few emojis. They appear to be laughing emojis.
And you don't have to mention the times right now until it switches a large time span. So go ahead.
The next would be an incoming message from Doug to Ashley asking ready to rock and roll. The next is from Ashley to Doug give me a few, LOL, trying to round up the cats. It's like trying to teach a ballet to squirrels. The next is an incoming message from Doug to Ashley, says ha with exclamation points. The next is,
And we've established that it's all either from Doug to Ashley or Ashley to Doug.
correct.
So if you can just say who's speaking and then the message from this point.
Number 12 from Doug, he says, that's funny. After that, it's from Doug, says he's liked, give me a few. It's basically liking a previous text message and it just repeats.
Okay.
The next is an outgoing from Ashley, says, OMG, I'm exhausted, LOL. The next is also from Ashley, you can come over now.
Now, I didn't ask you about the color coding on this, but what do the colors mean?
It was just to make it easier to read which one was outgoing, and on all the outgoings, which is Ashley's phone, are Ashley's phone, and the incoming is the other color.
And so the outgoings are what color?
The outgoings are the blue gray.
Okay.
Yeah.
Or the
Blue gray. The outgoing is the orange.
The orange. Okay. So if Ashley's speaking, it's orange. If Doug's speaking, it's gray.
Correct.
Okay. So I believe we ended it. OMG, I'm exhausted. LOL. Go ahead.
I believe I had stated the outgoing message. You can come over now. Number 16 from Doug. Hot. Need to video the rodeo. Okay, headed that way. From Ashley, she responds, she liked what he had said earlier and just repeats. Incoming from Doug, I'm walking around to back. The response, I could let you in the front, or which, and then adds to that, whichever. He responds, okay, front good. She responds with a thumbs up. He responds, me and XS boxes arrived. She responds, LOL. He responds with a message that includes an attachment without a body. Then there's a call log, which is number 26. It's an outgoing call log to Doug for, I believe, 11 seconds.
Okay. And then let me scroll down on here. After the phone call, what happens? Oh, let me back up just a second. What time was that phone call?
Same date, 9/27/24 in the evening.
And then at 8:58 in the evening, that next entry, what is it?
It is a message from Doug. It says, good night, sweetie, theta waves with a couple emojis. I'll be done by 1 tomorrow and plan on joining the party. And then there's an outgoing, and then again, another action of just loving that, that previous text message. And then there was a response at 9:23 that says, good night with a couple emojis. Ha, you sure you want to come hang out with the slum, ? And 9:23, he responds, yep, be smeshin' at the slummin'. 9:24, there was again an action of laughed at the previous message.
Okay, so that was at 9:24 p.m. and it looks like the next entry is at 7:36 a.m.
Correct.
And what is that?
That is believed to be an attachment without a body. It's a long string of characters, JPEG image.
And that came from Doug or to Doug?
That was from Doug.
And I'm going to display the attachment. You don't have to read all of this, but what is this?
Just another Bible verse.
So after the Bible verse, what is the next thing that happens?
She appears that she loves the image and then responds with good morning. He responds back with good morning with several emojis, and hours later responds with or says headed that way in about 30 minutes.
So that's approximately 3 hours later, he says headed that way in about 30 minutes.
Correct.
Okay, go ahead.
There's a response from Ashley that says, oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today, LOL. We'll have to round up the cats when we get home anyway. There's a response from Doug, oh, nice, a little breezy, which helps. Getting early start so can finish up early to come over and be with y'all and play W. Emerson, typically shorthand for with Emerson, free y'all up some, just ping when good to head over. And Ashley responds with a like of that previous message, and then responds with will do, and also adds in a new text message, want to grab a can opener at Publix on your way over, ? LOL. I of course packed the one we had. He responds, ha, too funny. Yep, we'll get one. She responds, thank you, trying to get the cats, LOL. And after that, there's an incoming message, appears to be an attachment as well. And that was that.
Go ahead. Some of these attachments don't open on this computer. Can you explain kind of why that is?
I think that one of the previous videos that you had, sometimes it's a codec issue. The files are actually not necessarily embedded in the actual spreadsheet itself, but I can take this same file and bring it over to another computer and it might open. It just depends. It depends on the computer, how it's set up to open that particular file.
Okay. So after the attachment, I'm trying to slide this back over. Let's see. Let me try to open this. Okay, so this is one that will not open. So I slid it back over. If you could tell us again, starting at 46, I believe it is.
Well, after that attachment, it's 45.
Or 45. Sorry.
And it's an incoming, it says from Doug, in the crazy loop at Gay, G-A-Y-E. And it's probably a misspelling because he corrected himself and put gate in the next message. There is a call log that has 0 seconds to it at 3:17, and then an incoming message walking around back, and then.
So the walking around back is approximately what time?
3 o'clock in the afternoon, or 3:21.
The next message is approximately what time?
9 o'clock at night.
And that message is?
Good night. And she responds at 9:22 with good night and looks like a sleeping emoji.
And the next communication?
The next would be an incoming message from Doug to Ashley, appears to be an attachment, some type of JPEG image.
And you don't have to read this, but what is it?
It's another Bible verse. I believe we're on, after that attachment, we're on 52.
Yes.
It is an incoming message from Doug. Says good morning with some emojis. Hope you slept okay. She responded at 9:28. Loved the image, or loved an image, and also an additional good morning. Doug then emphasized the good morning, just another action that he took on a previous message. And the next communication was at 11 o'clock a.m. with a wave emoji, looks like. And 11:22, he responds again with how's morning. She responds with also a wave emoji at 11:26, then says, good, the scramble to get all the loose ends tied up, LOL. He responds, no kidding, I'm done. Around 1, we'll head that way. Been going since like 3 a.m., LOL. She responds, OMG, 3, why is that? He responds, just to get work done so can pack. Love mornings all quiet. She responds, "Ha, okay then." He responds, "Spark is best friend, LOL." She laughed, another action for that message. And another response from Doug, "Finished up here, yay, headed that way."
And what time was that?
That was at 1 o'clock in the afternoon, 1:17.
And then after that?
At 1:19, she says, "Go take your time, no rush in, not in a rush today." And at 1:20, a response, LOL, with an emoji, "Think we all are getting pooped from the efforts." She responds with liked a previous message, and it just repeats. There is also a laughed at LOL, again, laughing at a previous message. Then another message at 1:36 says, "Can you think of anything we need at Lowe's or anywhere?" Then there's actual call log at 1:42 that lasts about 49 seconds. And that was from Doug too, actually. And then at 3:30, there's a message from Doug, "Headed that way in a few minutes. I'd nothing need." And a message from Ashley, "Alrighty, we are just out for a walk. Still can't think of anything needed at the moment." There's an action, liked already, and the message repeats from a previous message. Doing front gate, I'm assuming circle, but CIRCL. And a call log from Doug to Ashley with 0 seconds. Incoming from Doug, "I'm here." And it looks like another call log for about 20 seconds.
And that's about, I'm sorry to interrupt, that's about what time?
That was at 3:56 in the afternoon.
Okay. And the next message is at about what time?
9:26 p.m. It's a message from Ashley Christina to Doug. It says "good night" with an emoji. And then after that, Doug responds, "Good night, precious girls." And after that, Ashley, again, an action of loving that previous response. And the next several messages appear to be related to attachments.
Okay. So the next attachment I'll put up. Who were these attachments sent from?
These were from Doug to Ashley Christina.
And then in the middle of this, so it would be, I'm not getting the lines correct, but I think it's line 87 maybe, at 9:29:35.
9:29:35 is line 86.
Okay.
And that's another action of loving an image.
Okay. And there's one more attachment, I believe. Possibly one more after that. 2. So all of these attachments were sent from Doug's phone to Ashley's phone?
Correct.
Okay. And then there's a series of responses from Ashley. Can you tell me what those are?
It's the previous action that we've referenced where she physically takes an, it's not word that she's typing, it's just physically within the operating system of iOS, it allows you to take an action on an image. In this case, she loved 1, 2, 3, 4, 5, 6.
Okay.
6 images.
Okay. Let me get it back centered again. So after she loved the images, there's an entry where she types a message. What is that?
That's at 9:31 at night. She responds, "Oh, these are sweet, thank you." And he responds with an action that he loved the previous message, and then responds with "y'all rock, y'all rock my world with a heart emoji. And she responded again with an action of loving that previous message and with, it's a very small emoji, hard to tell what it is, after the action.
And then what's the next entry?
The next is an instant, is a message with an attachment, and that's from Doug to Ashley at 6:47 in the morning.
I'm gonna pull up the attachment. And again, what is that?
Appears to be another Bible verse.
And if you can continue.
So after, there's a message from Doug, says good morning with emojis. And then also an additional message at 9:28. It says, got an email from Stephanie after she talked to Faith. Since order to mediate will meet for 1 hour tomorrow. To stop court next week, you dismissed injunction. We signed joint stipulation to dismiss dissolutions and hold until Moreland signs. Order for report. As soon as she signs order, we file dismissal and we're done. Looks like praying hands emoji and a heart. And then there's an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots and red-blue inversion. After that, there's an action by Ashley Christina that said, loved an image. And it continues with a good morning. And there's an emphasis by Doug of good morning. Ashley Christina responds, oh, okay, I'll reach out to Faith to follow up on all the above with a thumbs up. Doug takes an action about and liking that previous image and then says, and we're done. Again, praying hands emoji. And also responds, and all in first 10 days of Jewish New Year, LOL. It continues with an action of laughed at the previous message. And then at 9:57, Doug responds, you gotta laugh, September 18th was first day of Jewish New Year, 3 years to date of your Odyssey starting day of ballet launch, Rosh Hashanah, the first of the Jewish days of awe. We can call our Odyssey the days of all, LOL. At 10:13, there's an incoming message, says from Doug, so perfect outside, looks like a sun emoji. Ashley responds with an action for those previous messages, which just repeats. And then writes, oh yay, we should do Selby today. He responds, oh yes, with multiple M's and yum. She responds with a few emojis. He emphasized the emojis and then adds, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do, just one pager, and also responds, what time thinking Selby? Ashley Christina responds with the action of liking it, and then says, maybe 1:30-ish, I'll text you when we're headed that way with a thumbs up. He responds, or Doug responds, okay, I can come pick you up too. Then adds more time with my baby. Then adds mediation tomorrow by Zoom 10:30 and be quick. Ashley responds with the action of liking that. Then added, sorry, just looking at my phone. You don't need to drive all the back to LWR to get us if you are already downtown. But if you want to, that's fine. Just let me know either way. Doug responds, I'm at apartment. Adds, so pretty, enjoying pool area, finally to work, LOL. The next message is an attachment with no body.
From Doug.
That is from Doug to Ashley Christina.
And I'll pull up the attachment. I don't know why I just closed that. Let me open it again. And what number were we on?
132, that was the attachment.
Thank you. Okay. So after the attachment, what's the next communication?
It's a message from Doug to Ashley Christina. I'll just head your way at 1:30. Ashley Christina responds, "Ha, nice. Okay, just getting our things together now. Maybe head over in like 10 minutes. 10 MIN." Doug responds, "Okay." And then after that is appears to be an email from Doug to Ashley.
Okay. And after that?
After that is incoming message from Doug. "Do you want to get together tonight or in the morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out." She responds, "Ha, okay, thumbs up." He responds, "Thumbs up. Prefer tonight, maybe run over Pandera or in AM, question mark." And she responds, "Sure, can do Panera tonight."
Okay, so I want to back up a little bit. We were talking about the entry that was the email before that. Does it have the content of the email in this spreadsheet?
Appears there's quite a bit of metadata involved, but the actual content from what I'm looking at is not actually in there.
Okay, does it say any names associated with the metadata?
There's an email address of Stephanie Murphy. It's at murphylawsarasota.com. There's an email address related to Doug Benefield. And there's, I believe those are the two names that I see that are associated with.
So we left off at sure can do Panera tonight.
Yes. And adds 8 question mark. She responds with a thumbs up. And that was at 7:27 p.m. And she responds with at 9:55 p.m. with a good night and a sleeping emoji. And he responds also with a good night with another emoji. He adds sweet dreams and then also sends an attachment. Correction, the sweet dreams was the last one at 9:56 p.m. The attachment I just referenced was actually 7 o'clock in the morning the next day.
Okay, so the next day I'm clicking on that attachment. And what is that?
Looks up here a Bible verse.
And what are the messages after that?
All right, so attachment. After that, there's a good morning with a few emojis. If you want, you can come over here for Zoom. And adds, we can grab bagel and CHI. It's 10 a.m. BT, by the way, BTW is for short. And then there's a phone call at 9 o'clock, 9:07 with no seconds. There's a 151. It says there's an incoming message with no body. And then after that, there's an incoming message with an attachment. It appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment and see if it will come up. It's one of those that will not come up. So go ahead.
The next after that appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues where Ashley Christina loved an image, then liked the message. It's 10 a.m. by the way, and then added, "Ha, oh man, okay, thanks for the heads up." He responded by liking that, and then added, "Set up here if easier for you." And she responded, "That's okay. I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone." He responds, "LOL, you can." She liked LOL, you can, and then added quick and easy LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added so nice to experience quick and easy. Finally, LOL. Then adds smeshing good. Then adds PS, you looked great for just rolling at a couch. LOL, and added an emoji. He added, I'm working on brief, head over soon as get to stopping point like 1. She responds with the action of loving the previous message, or one of the previous messages. So nice to experience quick and easy. Laughed at also the PS, looking great comment. And then added, ha, thanks. Figured I should put a clean shirt on even if I had PJs on the bottom half. LOL. She adds, and okay, just let me know as you're finishing up. He adds, just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul, more flexibility, like taking things straight to storage. She responds, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and cats will go in the Jeep and I'll drive with Emerson in my car. She added, LOL, the Beverly Hill. He added, LOL, the Beverly Hillbillies, coming from dem slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added, headed over shortly, brain approaching short circuit. She added, ha, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up. He added, he liked the previous message, and then there's a outgoing phone call to Doug for 38 seconds. Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night, with an emoji.
Okay. So the light headed that way was at what time?
That was at 2:00 in the afternoon.
And then the good night was at what time?
It's 8:27.
Okay.
At night. Saw 2 of them. Apologize.
And then after the good night?
After good night, there's an outgoing, indeed, LOL, good night, from Ashley. And then after that, there's an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
And the next entry?
Appears to be another attachment roughly 15 minutes later.
Okay. And if you could read what this says?
Live a life filled with love. Another Bible verse, Ephesians 5:2. At 9:26, there's a message from Doug that says, good morning. Minute later, there's an action of loving an image. Second, loving a minute image. And he responds with, Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
Chai. At 9:27, there's a response from Christina that says, good morning. There's a repeated response, previous message. Dr. Q is at 10:30. Do you want a chai? And And then Ann Bagel, he added to it. She responds, "Ha, that's okay. Thank you. If I do that this early in the day, I'll be done for the day. LOL, but thank you." He added, he liked that message. And the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open. And then the next entry.
It's at 10:40:35 a.m. From Doug, are you able to make it? Are you able to make Dr. Q okay? She responds, yes, LOL, be in a minute. He responds, no rush. He's still not out, LOL. She responds, I know, LOL, waiting for mom to come out so we can swap. There's a message without just a rectangular square there. And then after that, there's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now the LOL was at 10:42 a.m. and then what's the next entry?
correct. 10:42 a.m. was the LOL. And then the next is at 5:39 p.m., which is a phone call from Doug. And with 0 seconds. Then adds after the phone call, I be here. And then another phone call for 15 seconds at 5:40 p.m. Then,
Your Honor, not to attack Sergeant Quiles because he's been reading for a while, but it's a little tough to follow. I wonder if he could give us the number of the message, so it would be much easier to follow.
That's fair.
And I don't know why, but I think your numbers may be off.
all different from this.
They might be. Can you look?
IB here is, well, we're not using the numbers that are built into Excel. I want to say
Okay.
the
That's
numbers
what it is.
are an actual column. So technically IB
Hang on, I'll
here,
move this over. That's what you're looking at.
correct. IB
Okay.
here would be 212.
If he gives you that number, are you okay with that?
It's far left column.
Can you show him?
I got yours. 214. Just 214. These numbers here match what he's saying. There's numbers on the Excel spreadsheet showing that's what was confusing. But the numbers he's saying are the numbers.
Okay, so we're on.
We're
right
on
now,
215, correct?
Correct.
Okay.
Okay, so if you, Sergeant, if you could just call the number out.
Sure. Not a problem.
Thank you. Thanks, Judge.
Of course.
So we left off of 215, which is at 9 o'clock. It's a good night with an emoji. 216 is an attachment, a JPEG. And that was at 6:43 a.m.
And that is on the next day, correct?
Correct.
9/26.
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
And then you can continue from there.
All right, so moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds also with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log with from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message and then it repeats. 224, want to come pick me up and we can go get the truck.
And that's from Ashley.
And that's
correct?
from Ashley.
Okay.
And Doug responds, sure, with 225, sure, headed that way. 226, IB here. And that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening, and it's from Doug, and it's a good night, sweet dreams. Then at 228, 923, Ashley responds with the action of loving the previous message, and also responds with a good night. 230, there's another attachment at 642 from Doug to Ashley.
I'll pull up the attachment. What is that?
It's the Bible verse. After the attachment at 231, Doug sends good morning. 232, she responds, loved an image. And 233 with a good morning. 234, he responds what looks like a strong fist up emoji. And 235, there's also an incoming from Doug with just a little rectangle. 236, she responds with LOL. 237, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 238, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 239, how's it going over there? Making progress? He responds at 240, number 240 at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, AKA bed. Pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go. 241, he adds, I'll come there after drop him off at 3. .242, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds, 244 adds, great, could you run by Lowe's before you come over, grab a few large and mediums. 245, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure, I need a few, which just repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bits here. 248 from Doug, he likes the previous message and adds, and 249, okay, let me know anything else if think of. 250, she responds, tape. 251, and also adds LOL. 252, he responds, ha, K. 253, just finished vet, headed to spa, LOL. 254, she laughed at that previous message. 255, he says, headed there. 256, she responds, okay. The next line, 257, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two?
Correct.
Okay, so after okay, 1 minute, what is said?
Then 2:59, about to head back from Doug. And then the message after that appears to be an attachment at 5:11 in the afternoon.
And I'm clicking on the attachment for the record.
Now appears to be
Go ahead, I'm sorry.
it appears to be maybe the U-Haul truck that they're loading up.
And that was sent from Doug?
That was 5:11. Yeah, that was incoming. Yes, from Doug to Ashley.
Okay, and then the next message?
The next is from Doug, and this is number 261. everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
Thank you. Judge, can we approach just a moment?
Yes.
Before.
Maybe that's it. Hopefully that's it. Right, who's not liked the video, people? Who's not liked it? Come on. Get on it. Get on it. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. God, Josie. I didn't, sorry. Come on, Josie. I would have relied on you. I used to love vodka. Hated Jack Daniels. Jack Daniels, all those whiskey type of drinks, brandies. No, thank you. Give me a Malibu. I like fruity drinks. I do. So yeah. Dave's gonna smoke a bowl. Fuck. Go smoke, Dave. Thank you to those that haven't just liked. Just gained 7 likes. I need to get more songs. Let's hit the vape. Right, hopefully she's done.
Members of the jury, there's one legal issue that I need to resolve before we finish up with this witness's direct. So I'm going to excuse you in the back. It should take about 10 minutes, it's my best guess. So please don't begin deliberations amongst yourself. You can communicate outside, send and receive texts, emails, telephone calls, but just don't talk about the case. But don't do any research on the people, places, things, or legal topics you've heard anything about. I'll get you back out here as soon as I can. All right, you all can have a seat. Detective, I don't know to what extent we're going to be talking about the testimony you may have. So I'm going to go ahead and excuse you for right now, just to be cautious. Please understand the rules of sequestration. The rule of sequestration has been invoked. You're not to discuss your testimony or the answers you've given or the questions you've been asked with anybody outside this room. You're not supposed to talk with any other witnesses about the testimony they've given or the questions they've been asked. And to my understanding, this may be online. You're not to watch or view anything related to this case until you're released from your subpoena or the jury's returned a verdict in their discharge. Understood. All right. So just step outside and get you back in as soon as we can. No, I think it's fine because I think they're still going to mute them down. I can see all right. Okay, the detective is out of the room. We can have argument on this video.
Thank you, Judge. And thank you for rehearing the issue. I had a chance to research and we obviously weren't.
If you've got case law, contrary to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thank you, sir. I actually just sent one to the printer because I didn't know if you'd rather have it, but it's called Lumark. I don't know, Lumarque. It's 44 Southern 3rd, 171.
Say that again.
Sure, 44 Southern 3rd, 171. There's a yellow flag, but it's for a different reason. This case was,
Sorry, Judge, are you looking it up electronically or would you like a hard copy?
No, I'll take a copy if you have one.
Oh. Give me 1 second, Judge. Sorry.
Oh, that's all right. Is that the only one you've got? No, you can have it.
One at a time. I can do it, Judge.
We printed this for you, but then realized we needed 2 copies, so here's the paper.
It's not off the front. Oh.
Judge, they revoked my copy in favor of the court.
In favor of the court's.
We're not gonna do anything until you get a copy.
It should come any second.
Of course, I can't blame their decision, Your Honor.
Hello, Shari. How we doing, my darling? All these drinks now, we're all going to start drinking. Alcoholics. I don't like rum, don't like any of that kind of stuff. Clear, gin, vodka. But I don't really drink anymore, so. Pims. I will drink Pims. I like Pims. Pims with fruit and
Right,
stuff.
go ahead. The part that I'm referring to is on the second page. It's a short case, luckily, where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law. That's my understanding and my feeling, but that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third DCA here said the court erred. The images and text messages were found on the defendant's cellular phone.
Can you slow down just a little bit for the court reporter?
I apologize. The images and text messages were found on the defendant's cellular phone, seized pursuant to a search of the defendant's home through a warrant shortly after the alleged incident. This fact was testified by the state's forensic expert and is sufficient to authenticate the exhibits. Here, those phones have been in evidence since the day before. The contents of them were admitted with a trial exhibit today and not objected to. The only thing is this one video was objected to, this attachment. And the state would argue based on this case that we have established this phone was properly searched, properly downloaded, and the material was found on the defendant's phone, the video, found on the defendant's phone, and therefore the state argued it should be admitted.
All right. Mr. Taylor?
Just 1 second, Your Honor. Okay, I distinguish it on 2 bases, Your Honor. They quote U.S. versus Caldwell 11th Circuit decision, holding that authentication of evidence merely requires a finding that the evidence is what it purports to be. Well, that's the exact issue. Sergeant Quiles cannot do that. He can only say this is a video, it was on the phone. He can't say it's a true and accurate reproduction of what took place on that morning. He doesn't know, for example, who was there that might not have appeared in the video, what the motivation was that brought them there. He wouldn't be able to say whether it was under coercive circumstances. I don't think he qualifies to be able to lay that predicate. And second reason why I don't think this case is applicable is in this case, they held that it was admissible because it constitutes evidence of motive. Judge, this is a second-degree murder case. As the court knows, motive in second-degree murder is not an element. There is no obligation that murder be proven. I don't think they can lay the necessary predicate wrong.
state rebuttal?
Just that I think defense counsel's arguments go to the weight, not the admissibility. I think this case stands for the fact that we've entered, without objection, cell phones that contain this video, and then now without objection, the trial exhibit with the attachments and the CD. The objection was just to one after, which I think is also an issue, but I think we don't have to get there. But I think this case stands for the fact that once we've laid the predicate that this was a properly searched phone and that the data on it was properly removed and the detective testified that everything was in order, then we've laid the predicate for the contents of the attachments to also be admissible based on this case that I can't say the first name of.
What was the date and time of this particular message?
The message was, I don't know that you can read the small print on that, but there's a copy, but it is, if you're wondering if it was before the Panera conversation or after.
I want to know the day and time that this attachment was sent.
It was sent 9/20 of 2020 at 6:40 p.m.
What number are you referring to?
Oh, 25.
And the Excel spreadsheet, which is the data dump from the defendant's cell phone, shows it's in blue. So it's from,
Defendant's phone. So it's from the defendant's phone to, I'm sorry, from.
correct, it's
the victim's
from,
phone to the defendant's phone.
right, it's from Doug Benefield's phone
Yes.
to Ashley Benefield's phone.
Yes.
All right, any further argument? Because I wanted to ask that question, though, specifically when.
No, sir.
Anything else?
No, no.
All right. No objection or no judge?
I thought you said, do I have any further
Anything
argument?
else? And you
Yeah,
said no?
And I don't, no judge, sorry. Yeah,
Okay, well, as I said, if there's case law out there that is contrary to a prior ruling, I think it needs to be brought to my attention. And what State versus Lumarque, Lumarque, 44 Southern 3rd, 171, at 172 to 173, Florida 3rd DCA 2010, states pretty unequivocally, the images and text messages found on the defendant's cell phone seized pursuant to a search of the defendant's home through a warrant, which it wasn't here. It's my understanding, the testimony that I heard was that they were provided to law enforcement. Shortly after the alleged incident, this fact, testified by the state's forensic expert, is sufficient to authenticate these exhibits. So the issue is authentication, and that's where I had initially sustained, because I obviously there was got to be no witness. This Quiles, sorry.
he says keyless entry, that's how to remember it, it helps me.
Quiles certainly could not authenticate the video. And just to be clear, I'm not sure, I think it's on the record that it's going to be a video of the defendant and her mother that's taken by a third party. I outlined it pretty in depth in my order denying the stand your ground. And like I said, certainly the technical services unit couldn't authenticate it, saying that it's the traditional way, that it's a fair and accurate depiction of the events of that day. So then I had mentioned that the bench, perhaps the state could lay the silent witness predicate. However, I don't find that the silent witness predicate was sufficiently laid by the detective Quiles. However, apparently, according to this case, it is authenticated by the fact that it was found on the defendant's cell phone that was seized shortly after the incident. And at this point, it's been sufficiently testified to by the state's witnesses and the forensics expert that he
did find this video on there. In fact, in addressing the defense arguments, the third DCA goes on to say, regardless of how these images and text messages might have found their way onto the defendant's cell phone, the state has presented sufficient evidence at this stage. Certainly, they met the admissibility that these exhibits constitute evidence of motive. As we've discussed, motive is not an element. But the state has made the argument in the past and makes today that the entry of these items is not for the truth of the matter asserted, but to show the relationship and interactions between the parties in the days leading up to the homicide and the normal texts and banter and communication of a married couple that is in the middle of a divorce. So for those reasons, I will reverse my prior decision, and the video would be admissible under this case.
Thank you.
So we did that specifically so you could finish with your direct,
Yes.
and the ruling is made so then it's available on cross. I know we talked about different options, but I'm glad we did it that way because I think it makes a lot more sense.
So we can recall him and play it, and then we'll attend to the witness.
Correct. So when the jury left, he was on the stand.
Oh, I'm sorry.
Right, so I'm just gonna put him back on the stand. The jury won't know any different.
I'm sorry.
All right, so if we can bring,
Can we take a quick restroom break?
all right, 5 minutes?
Just 5
Sure.
minutes.
Okay.
Thank you, Judge.
Okay. So we get to see the video. I had not heard that about Chris Watts, to be quite honest with you, but I've heard a lot about him. Who's NK? I don't remember her name though, so I need to look that up. I didn't notice if Eva was still back in court or not. Damn. She's in Rice. I did not notice that. If anyone did notice, is Eva back? Excuse me, in court. You got 5-minute break. Hang on, what's that now? 2:32. Okay. So you can go and stretch your legs, whatever you need to do as well. Is he only 39? Chris Watts is only 39. Friggin' Nora. Nicole Kessinger. Okay. Thank you, Young. I did not know he's only 39. I thought he was a lot older than that. Crystal. Hello, my darling. I always believe Nicole played a role. She's sketchy, to say the least. I obviously watched the whole thing around him. I've been intrigued by that case, but I don't know too much about it. You know, Chris Watts, who alleviated his 2 children and his wife. Is it in Idaho? Not Idaho, sorry. Utah? I think it's Utah, something like that. It's a few years ago now, Dave. Your memory's probably gone. Hey, Crystal. Nice to see you, my darling. So yeah, at least with this, go back to this trial, at least we get to see the video. I don't know what the video is about. I don't know what we're about to see. He declined it in the pre-hearing, but he's now allowed it in. Colorado, thank you, Hackster. She's fucking everywhere. Hack is everywhere. You can't hide from her at all. Bloody everywhere. Duh. So yeah, so we're going to get to see this video. Then there's going to be a cross-examination, and so we'll see from there. This is a long witness. I hope the other two aren't as long. Well, I think they are, but is that a dog? Erin is the dog. Is that a dog, Dave? I can't see. Are you calling Erin a dog? Zowski. I'll Google it. I've seen a lot about the case. It's just more of a. I'm intrigued by it. Chris Watts is evil. Yeah. Oh, sorry, I forgot. Quizzical Girl. I forgot. You're right. Unborn baby as well. a while back I watched a guy outside the home, he killed her, and he had a ghost. Oh yeah, I've seen that. I've seen that as well. He is very evil. I watched the whole thing, and the next door neighbor with the whole, he was watching the security cam, and wow. Hello, Casey. How you doing, my darling? From Stoneham. Hello from Stoneham. Hello to you, Casey. Sorry I'm late. Work gets in the way. Bloody work. Work. So Erin is a bloody goat. She a bloody goat. Yeah, Dave knows. Dave knows now what it is. It's just he's so old. He's 69, you see, so he didn't remember. Crude oil tanks, like yeah, they were huge. But also, why would you know? I mean, I don't know. I don't know what he was thinking. You know, but goat, greatest of all time. That's me. That is. Hey, babe. Police cams. They were paranormal activities. Dylan loves me. He just hates to say it. The more love I show you, Hack. As I've always said, a love-hate relationship here. I love her. She hates me. So it works well. It works well. That's the mod. I love all my mods. They all hate me. So that's how it works so well. Hey, Amy. Elder abuse. Nah, only Dave, Sassy. Everyone else is fine. Dave, I gotta give Dave a ribbon. He's been here for about a year now, and he has to be put into place, Sassy. Sometimes he has to. If you know Dave, you know that he's got to be put in his place. Like oil and water, match made in heaven. All right. So I know today's been a little bit boring to start off with, but only after this guy, two more to go. So hopefully we're done today. Then we should be done. We should be starting the defense witnesses today. Hopefully, fingers crossed. That'd be quite nice, wouldn't it? I wonder how many of them are they going to recall the defense. I know he wants to put. Oh, and also there's going to be an in-court hearing because he wants to. He says that the lawyer perjured herself under oath. So, vinaigrette. Yeah, you're all good, Sassy. Sassy, there he is, the ladies' man. Do not take the flowers from him, Sassy. He's a ladies' man. The only person that if Wendy was here, he would not be handing out flowers. Wendy is his favorite, so don't be fooled by David. Thought you said babe, not Dave. Made me think of Cher. There's a Cher rubber ducky on Amazon. Babe. Dave's a babe. Hello, Mia. Thanks for popping in, Mia. Nice to see you, my darling. Hope you're well. Saw you yesterday and today. Nice. I'm standing atop about 60 million gallons of crude right now, and I certainly wouldn't want to be in a tank, dead or alive, nasty stuff. Out to sea, yeah? You're out to sea. He is. He is.
All right, can I go ahead and bring Detective Quiles back
He's out
in?
on sea. Good girl, Sassy. Oh, no, Gitmo. Now, Dave shaving. Hey, get to land, dog. Make sure you get to land safely, my friend.
All right, Detective, if you can retake the stand, reposition yourself as needed.
Camera, please. There you go.
So did you speak with anyone about your testimony or their testimony or anything at all?
No.
Ready to bring the jury back in?
Yes.
Mr. Taylor?
Yeah, sorry.
Bring him in. All right, y'all can sit down. Welcome back, everybody. Anybody begin deliberations, communicate with anyone outside the jury about the case or do any research on the case? All right, everybody says no. State, you can resume your questioning.
Okay, I just have one thing before I turn witness over. There was an attachment of video that was sent by Doug. It's line 25. So sent by Doug to Ashley, correct?
Yeah, hold on.
Oh, you don't have the sheet in front of you.
No.
Sorry.
Thank you. Line 25 is an attachment from Doug to Ashley Christina.
Okay, I'm going to play that attachment at this time.
I don't even know what it's doing. I think it's giving you clues that I gotta guess.
Not safe.
Get real?
Second word.
Real?
Working mother. Not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum. Oh no, it's running out of time.
I live in
House.
a
Real house. Wife.
It was together.
Oh, housewives of. Oh, real house. Oh.
Okay, thank you. I have no further questions.
Cross. And Mr. Taylor, do you want the screen or do you want the lights back up?
I'm gonna use the screen.
Yes, sir. We'll leave it as is.
Do you want your?
Good morning, Sergeant Quiles.
Good morning.
I want to make sure that we can establish the contours of your testimony. From the technical services unit, you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the messages. You just are able to read what's printed.
I can read what's printed from the extraction, yes.
Right. But for example, there were quite a few Bible verses. You wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I could tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
I would object to be on the scope.
Okay, I don't know.
Come here, bud.
Here we go. Back to Can We Approach? I think it's just to show again how they got on well together, because she's claiming that, you know, she's got abused by him and stuff like that. So I think the prosecution trying to show, look, he never abused her. Look, they got on very well together. They're so happy. They're lolling together. There's videos of them together, stuff like that. Essentially. Sea Dog, we are sailing round the sea, round the sea. Okay, they're coming back, right?
Not yet, no.
I'm going to pass to you, Sergeant Quiles, what I've marked now as Defendant's Exhibit 3. Those would they not, text messages that you also extracted?
I believe these were the text messages that you may highlighted during a deposition, and we confirmed that these came from, I believe, Doug's phone.
Correct.
Yes.
And that we requested.
I apologize, Judge. I do think we need to approach it.
I mean, this is, come on, prosecutors. Why are we approaching all the time now? Also, yeah, that was her mother next to her. I mean, if these are Doug's text messages, it's you know, her mother's not in the courtroom. Her mother is not allowed to be in the courtroom because she's been subpoenaed to reappear potentially by the I think that by the state. I think the state did it deliberately so she couldn't be in there. So no, she's not there, which I think is bullshit. But I think if all text messages are coming in, they should all come in. I don't think they should be like, or pick and choose and stuff wherever. I wish we could hear. At least Ashley gets to hear it, but I wish we could hear what's been said. Hey Dan, isn't it time for a song? I do realize that a lot of people do not like the songs. It is I honestly, right, I would have a lot more followers and lot more people watching me if I didn't sing. I get lots of complaints about the singing, but I love it. I love singing. Thank you, Dan. Thank you, my friend. I don't have a song in me right this second, but a lot of people hate them, so I'm trying to rein them out a little bit. Because normally when I sing, people actually do drop out the stream, especially new people don't understand why the fuck is this guy singing. Oh. No, I know you are, Steph. No, it's more like I generally do understand why some people don't like it. And people have spoken to me about it nicely as well. She said, I can't watch you because you sing. If you didn't sing, I'd watch. I just can't do it. I'd rather keep it about the trial, which I respect. I respect. What's this shit? This is from Joni. This is Boston. This is Boston. This is a gift I got from Boston. This is the whole of Boston. So we've got Peabody and all that. Worcester's in here somewhere. Dedham, Canton. So yeah. Joni sent it to me. So shout out to Joni. I like the songs. No, I do as well. I'm not going to stop them. I will still sing, but yeah, just explain. We do lose a lot of people because of the singing, which sucks a bit, But I get it. It's not everyone's cup of tea. My mum sang around the house all her life. I love being singing. Oh, good. Ha 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 ha. Amy. Okay, I need to put that up there. Hey Jude. That's a different one. I love the songs. Haha. I need to incorporate some Disney ones in for you, Carol. Oh, boring. Yeah, I know. I get you. Oh no, yeah, you guys are here. You love the singing. It's all good. It's more like I'll try and learn it. Hey, Maureen and Woo. I should put a scroll across. I shouldn't I? No, most people. Well, I mean, it's more for the new people. For everyone that does like the singing, is like 5 that don't, which I get. I get it. But you need to be authentic. You see it now, Josie. I thought it was a ship. You thought it was a sea dog. I know, James. It's all good. Thank you, James. I'd say, hey, what you see is what you get, and it's all good. I enjoy it. I'm not going to change. I'll still be singing. It's just, yeah, I should put a warning up, shouldn't I? There will be songs, and there will be songs without the correct words on there. Nice. What you gonna do? What you gonna do? Da 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 da. Bad boys, bad boys. What you gonna do? What you gonna do? What about bad boys, bad boys? Who said a whale? The young say a whale. Since we talk about the sea, I see a whale. Thanks, yeah. Fucking hell, everyone's calling me a whale now. Look at this. Like a nightingale. Yeah, I love singing. I love it. I just wish sometimes I'd learn the words. Oh wow, I didn't know that. Hey Jude. I just I need to. I should learn the words a bit more. But yeah, Mum's favorite song. Wow, Judy. What do you do with a drunken sailor? What do you do with a drunken sailor? What do you do with a drunken sailor? Early in the morning. Da-da, Sea Dog and Dana, ooh, Sea Dog and Dana, ooh, Sea Dog and Dana, both are sailors now. Dana used to be a sailor, Dana used to be a sailor, Dana used to be a sailor, over and resistant to silence. Go subscribe to Dana and Tracy. No, I can't make a song out of that. So Sea Dog and Dana from Resistant to Silent People. He used to be a sailor. Yar, me sailor. Who are me sailors? And Sea Dog is a sailor. Ole, 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 ole. Erin ha.
All right, members of the jury, this is going to take a little bit longer. So what I'm going to do at this point is, it's about 11:30. I'm going to let you go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45. That gives you a little bit extra time. That'll give us time to take care of what we need to take care of. And we'll get you back up here as soon as we can right after your lunch break. Please remember, don't discuss the case amongst yourselves. Don't discuss the case with anybody else. And don't do any research on the people, places, things, or legal topics you've heard anything about. All right, thank you. All right, you go ahead and bring up the lights. Okay, Detective Quiles, we're going to let you go also for lunch. Just remember the admonitions from earlier. Don't discuss the case with anyone. Don't let anyone discuss the case with you. Don't talk with any other witnesses. You can't talk with the attorneys about their testimony. Don't do any research or watch anything online. Understood. If you could be back here at 12:45. Sure. All right. Thank you, sir. Okay, we'll see you back here at 12:45. Okay.
Oh, we're all breaking for lunch. Hi, Diane. How are you? Right. Let's get it on. So they're coming back at. Are they coming back at 12:45? Right. Okay. So 12:45. Oh fuck. Right. Hang on then. I'll put some Trigos love on for you ladies. Hang on. Lunch break. Let me put this on here. 12:45. 45. All right. I will put Peter Trigos. He did a stream last night about this, so I'll put him on for you, ladies. Let's drop it in, ladies. Let's go. I know you know. Peter Trigos knows. Bam para bam bam. Bam para bam bam bam. Okay. Okay, where's he gone? Oh, actually, this should take us exactly to 12:45. Right, hang on. I will be back by 12:45. If the stream comes back, I'll be back for it. But yeah, here we go, everybody. Ladies. Bow chicka wow wow. Bow chicka wow wow. Right, and some of the gentlemen as well. Right, so here you go, people. Right, I'll be back at probably before 12:45. But here's what Peter Trigos has to say.
What's up, everybody?
What's up,
We've got day 2. the Ashley Benefield trial, where we had some hostile witnesses, one main one that will be highlighted in this video, but also some witnesses that were hostile toward the state that I'm not sure why they called. And then near the end of the day, the judge very clearly and unabashedly slams the defense lawyer after sending the jury out of the room to reprimand him on the record. It wasn't good for him. But how did it affect the trial? How's it going? How far along are we? We're going to get through all that. We're going to answer all your questions. Make sure you guys hit the like button and let's get to it. So yesterday, you guys absolutely crushed it with the likes. I think we had like 15,000 likes or something on that video. So we're in. We're invested. We're in on this trial. Well, we will be doing recaps daily or just about every day, bringing you what's happening, reacting, explaining, answering questions. So make sure every one of you that hit the like button yesterday, hit it again today, and we'll keep moving along in this trial. So it started out with the first two witnesses called by the state, Alicia Byers and Barbara Russell, who seemed to be very friendly with the defendant. Alicia Byers is her mom, obviously, no surprise there. But as I'm listening, and they go quick, I mean, this state, I prefer this over dragging it out and over trying the case and making the case take forever. But I do think there's a way you can shorten it and do the keep it simple, stupid KISS strategy a little too much. And they have to be careful with that. But I also think there are issues with their case they don't really want to get into with their own witnesses. So it seems like they're trying to rush some of their own witnesses on the stand. And I got to be honest, I've done that before in cases too, where you have a couple things you got to get out of the witness, but a couple things you really don't want to talk about with the witness. So you get in, you get out, you move on. And I've felt that a couple times. So I was listening to these first two witnesses, and we're going to listen to almost the entirety of the mother on the stand. This is the mother of the defendant. And, you know, you tell me basically, what is the point of calling her if you're the state? Just because you knew they were going to call her, you didn't want them to accuse you of trying to hide her. I think it would be expected that the mom would be called by the defense, but the state called her. And at first I was like, whoa, all right, let's, get out our popcorn. Let's put our listening ears on because they're calling the mom. Is she going to say something bad for the defendant? Which just highlighted her testimony even more. So let's take a listen.
Can you spell your first name and last name, please?
ALICIABYER.
With you in Florida.
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
Okay. And she was married at the time, but it was just Ashley that moved in?
Yeah, he brought her down.
Okay.
And yes, and yeah.
And she moved in with you?
Yeah. He told me I needed to take care of her. He dropped her off.
Okay. So.
All right. Right about there, I was like, okay, she's not going to be good for the state. Because why did the state even ask that question? Because that's the first bit of legitimate firsthand knowledge and information we have as to how and why Ashley went down to Florida. Because when I heard that yesterday, I thought it was a good fact for the state. Like, whoa, she gets pregnant and immediately leaves and goes to live with her mom. Maybe this was a plan. What are they getting at here? A lot of you said she had issues while she was pregnant and it was a lot and she was dealing with a lot of pain. And if somebody's not going to take care of her, doesn't care about her, she needs somebody who does. That's why she went to her mom. Well, now we have evidence on the record called by the state in their case in chief that he drove Ashley down, dropped her off, and was like, you got to take care of her, and left. And that it was seemingly his decision, according to the mom. Maybe we'll get more information about this later, but that was not good for the state.
She stayed with you from that time on, correct?
Yes.
Okay. And does Ashley have a concealed weapons permit?
Yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms?
Yes.
Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or anything? I'm sorry.
Yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Fantz?
I'm not sure.
Okay.
I don't know.
Okay. And you and your daughter obviously are very close. You lived together, just the two of you, right, for a while.
Mm-hmm.
And then once the baby was born, the baby lived there with you.
Correct.
Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mm-hmm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay.
He had found his dream job.
So he was moving to Maryland, but not moving into your same house?
Correct.
Okay. And he was packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
So he was there basically daily the last week, which I found is an important fact.
Somebody rented a U-Haul. I don't know who.
It was in your driveway, though, correct?
No, it was not my driveway.
The day that shooting happened, was it in your driveway?
I think it.
If you don't know,
the U-Haul was getting there when I was leaving.
Okay.
Yeah.
But you also had a pod?
That was in my driveway.
In your driveway. Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. When you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then?
Yes.
When you left?
Mm-hmm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
No.
You've been in contact with her basically every day.
I mean, that's as leading as it gets, but no big deal. It's kind of foundational, whatever.
Correct.
Not initially, no.
For the last several years, you've been in contact with her every day.
Well, yeah.
Okay. And
no, okay.
That's literally cross-examination, but also potentially treating her as a hostile witness. Because she's definitely a hostile witness. She's not yelling, she's not angry, she's not screaming, but she is not a good witness for the state.
Did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park,
she even said when she had to shoot Doug there. But that right there, in case you missed it, I think that was the important fact the state wanted to get out with this witness and the next witness, that these people are the closest people to Ashley. She talks to them all the time, and she never once told them what happened. Now, the defense ends up kind of talking about why somebody would or wouldn't do that. But I think the state's point may be well taken. And I want to know what you guys think in the chat, where it's like, you got your girlfriends or your mom or whoever the closest people are. If this big event happened to you, would you at no time, you really thought it was self-defense, would you at no time be like, I can't believe he did this, I just had no choice, whatever. I think that's what the jury's trying to plant, and maybe the other female jurors and male jurors' minds. Like, what would you tell to your closest friends? Would you really say nothing? And we'll wait and hear how her defense team handles it. But I think that's, the big thing they wanted to get out of this as the state.
I'm assuming she was already in the squad car, or she was already with law enforcement?
I have no idea where she was.
Also staying.
Okay. So at the time that the shooting happened, she didn't tell you what happened?
No,
correct?
We've never talked about it.
And to this day, you've never talked about it?
No.
Thank you. No further questions.
That was it. And the cross is basically, you took your granddaughter to the park all the time. This wasn't like a one-time thing. Ashley didn't instruct you to take her out of the house and get out of the house. Because again, these little factors that might not seem that important, the state kind of wanted us to think that. I felt like the state wanted me to think Ashley had this plan. She got her daughter and mom out of the house so she could do this deed. That's gone now. And it doesn't even seem like the state's trying to argue it. BB, lawyer, I am confused about what the state has to prove. That she was not abused or that she was not in danger at the time of the incident. Also, I live in Orange County, nervous I may get called jury duty for Sarah Boone. Well, if you've been paying attention to the case, you might not be able to even be on that jury. But so they have to prove that she obviously did the deed, which it seems like everybody's admitting at this point, and that she was either not in fear of serious bodily harm or death at the time of the incident, / because of the battered spouse syndrome, that her fear was not reasonable, even knowing the context and the previous physical or emotional or abuse that may have put her in fear in the past. So there's additional context than just your average everyday self-defense case with the battered spouse syndrome based on the history and the domestic relationship between the victim and the defendant. Dorothy, why does Ashley get to hear the sidebars with headphones? Is this a Florida thing? Please explain. So I've never seen a judge say no, a defendant can't be involved or listen to sidebars. It's their right to be involved in their trial. They should be able to hear what the arguments are. They should be able to hear if what their lawyers are saying is correct, right? Their life is on the line. Their liberty is on the line. Some don't want to, some don't care to, some lawyers don't push it. And there are different ways to do it. The defendant can walk up. Sometimes they can't walk up because they're shackled. I don't think she is, but there's another easy way just to listen to it on here. So a lot of times we try to find the best way to let the defendant be as involved as they want to be in their defense. What's up, Miss Melody? January. If the prosecution calls a witness, doesn't it limit the defense's scope for cross? Sometimes judges don't care because if the defense has a right to call them anyways, they'll give them more leeway with cross, but you don't have to call them because the defense can still just call them in their case in chief. So it really doesn't limit the defense to call a witness. I never felt like that really limited the other side if they have the right to call that witness on their own. All right, then we get to Barbara Russell, who is a licensed mental health professional. Ashley moved into her house for like 8 months at some point. They talked all the time. They seemed to be friends. She was not friendly to the state either. But basically what the state wanted to get out of her was Ashley never told you, her very close friend who she lived with, what happened that night either. She confirms, never talked about it once with her. But then on cross, the defense gets this question out that I think, clears the air in my world and in my mind, but I want to know from you guys, the lay people, is this a good enough explanation as to why somebody wouldn't tell their closest friends and family members about a night that affected them so much that they believe was self-defense? And this is kind of the explanation here. So let me know what you think about this.
To discuss the facts, correct?
Of course, any good lawyer would do that.
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
So I'm kind of surprised that was able to come in. It's hearsay, potentially waiving part of the attorney-client privilege. There are some arguments I could have made about it, but I guess because the state's making such a big deal, maybe the judge felt like there was an exception it could fit in to explain. But that's basically the explanation. You're aware her lawyers told her and instructed her not to talk about the case. We've heard multiple times, and it pisses me off when I hear it, and we'll talk about it later, that she was almost immediately getting lawyers. And by the way, if something like this happens and you're claiming self-defense, you should get a lawyer right away. And she confirms her lawyer told her not to talk about the case, and Russell says any good lawyer would. Is that enough for you as lay people, as not, attorneys that have practiced criminal defense and prosecuted cases and understand how this works and don't think people are guilty just because they hire a lawyer, but lay people out there who maybe haven't had as much experience with the law or the legal system, do you think that's good enough? Okay, see, I see some of you guys saying, I don't buy it. I can't believe she didn't explain it. Some of you are saying, absolutely, it makes sense. Yep, Denise, that's good advice from a personal injury lawyer as well. So I do like hearing how you guys feel about this stuff and understand this stuff. Is that the dancer or the dancer's mom? I know nothing about this case. This case hasn't hit national eye yet. It's pretty big, in my opinion. And today was a very anxious day. It was a high energy day, a lot going on, a lot of issues, a lot of things happened legally in the case. I felt like I was, learning and reacting in real time, listening to this. And that doesn't always happen with the cases I watch and listen to. So the first witness was the dancer's mom. This is the dancer's friend. The dancer is the one that's the criminal defendant. Peter, my daughter wants to get her paralegal certificate. Is this a dying trade? Can't AI do this work now? I think a good paralegal is always going to have a job. I think we're always going to need paralegals to assist, to bounce ideas off of, to help us draft things. I think AI can take the place of maybe some legal assistants, maybe some law clerks even, but I don't see AI really taking over the legal industry like some people do, but I don't. Jody, thank you, Peter. Love this channel. Love your delineations, explanations, and never-ending dignity and honor. Much gratitude. Thank you, Jody, so much. I love it when people reach out and tell me things like this because, a lot of times there's some negative stuff too, and I take this stuff seriously, and I try to do my best, and I try to stay unbiased and just tell it like I see it. And I know people aren't always going to agree with me. In life, that's how it is, and I get along with a lot of people I disagree with, so I appreciate that because I'm sure Jody and I have probably disagreed on a case or something with all the hours I've been on YouTube. Adam, Peter, there was a few questions that commented on the fact that She never told why she killed him. Is that legal? So telling her friends, yes. The fact that she didn't talk about it, fine, yes. But we know she told the neighbor right away because he said it on the 911 tape. We know that's what they're arguing. The defense said it in opening statement. She just took her lawyer's advice and didn't talk to anybody about the facts of the case because she didn't want it to be twisted and used against her. And guess what? Twist and use law enforcement and the prosecutors would have done. Let's see what else we got. He tried to get into some of her conclusions. I'm surprised he didn't get into that more about what Ashley's disposition was, what her demeanor was like. This was really big for the defense. Again, with a state witness. And this is kind of, outside the scope of cross if you want to argue that, but there was no objection because I don't think it's a good objection when the defense can call her on their own. But she was able to talk about how she saw and talked to Ashley the day after. And while they didn't talk about specifically what happened, she was able to view the injuries on Ashley and talk about how they were different than the day before the incident.
21, picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach you? Yes. Does that picture reflect any swelling to Ashley Benefield?
Objection. As interpreting the picture.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay, what was different about her?
When I saw her after the incident, there was edema, sweat swelling on the side of her face.
Okay, and did that include her right eye?
It included her left eye.
Left eye, rather?
Yes.
Okay, and when you saw her before the homicide?
That's a witness that knows what's up when she's correcting the friendly lawyer on which side of the face the injury was on.
Did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection. Here's some question.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we vote?
Yes.
So she eventually confirms the head pain. And what I put in my notes is if the jury buys and believes that Doug hit Ashley in the face or head that night, it's over. It's over. Physical differences, strength differences, the context of what he's already admitted to. If he actually hit her in the face, I don't care if he was armed or not, in my opinion, and most Florida juries would find that to be enough to put a woman in fear of serious bodily harm or death. Now, are they going to buy that? I don't know. Was this enough for that? Not necessarily. It's not like they proved it beyond a reasonable doubt. But this is the second witness of the day for the prosecution. And this is the type of evidence that's coming out. Next, we get Officer Dickerman, who took the stand. He explains what they did at the scene. He's the one that talked about how the mom was there. She handed him the phone. At first, he wasn't sure why she handed him the phone, but then he found out there was a lawyer on the phone. Dun, dun, dun. And if anybody calls a lawyer, they must be guilty. Now, he didn't testify to that, and the state didn't say it, but shame on them for even trying to insinuate it. It's a violation of people's constitutional rights. It's overstepping. It's something I don't respect when state attorneys do. In our members only live today, we talked about good state attorneys and, what we like out of prosecutors and judges and things like that. You do stuff like this, I'm not interested. Don't do it. Don't use a defendant's right to remain silent, right to competent counsel and effective counsel against them. Because guess what, Mr. State Attorney or Miss State Attorney, I guarantee you'd call a lawyer if you got accused of a crime, whether you did it or not. And Katie said, innocent people need a lawyer. It's not just for the guilty. The way the prosecution tried to insinuate something different, so far I haven't heard anything that proves she's guilty. And you lose credibility with me if I'm on the jury. Now, everybody might not be like me on the jury, right? There's a lot of you guys that think very differently. But I hate that. I hate it. And it's not just on the cop, it's also on the prosecutor. It's more on the prosecutor. Chris said, I'll never understand it. If she blabbed all over town, people would be giving her grief about that. But she says nothing and they still does the wrong thing. Yeah, she was trying to get her story straight. She was trying to make sure everybody knew, what she was saying and everybody was on her side. That's what they would have said, Chris. You got it, bud. That's what they do. And at the end of the day, keeping your mouth shut, blaming your lawyer for that is the way to go. My lawyer told me to keep my mouth shut. I trust him with my life. My life is literally on the line. They're saying I did something I didn't do. I'm going to trust my lawyer. Period. And guess what? That's why the situation and the system is set up the way it is. Good lawyers protect their clients. They talked about CPS being called. He explains what CPS is, how when he did this investigation and things, the defendant's mom wasn't completely cooperative. But basically on cross, the defense is like, so you proved they got a U-Haul, the deputies arrived, and there was a homicide. All homicides are not capital M, are they? And he says no. And then he tries to say, if somebody worked in your department and they thought all homicides were first degree M, that'd be a problem. The objection was sustained. So we can bet there's going to be somebody coming later that basically thinks all homicides are M's. And then there was other parts where they're like, the defendant wasn't even arrested yet. You didn't arrest her till a month later. And this cop said, well, yes, the defense was like, she was locked in your back seat of your squad car, couldn't get out, handcuffed behind her back. Most people would call that being arrested. Okay, we don't need to get into legal semantics. All right. I'm going to answer a couple questions before we get to one of the bigger witnesses of today. Can you explain the release of subpoena in this case? Cousin did an interview with Vinny. Is that a violation? So I'll explain it. I don't know anything about the interview, so I'm not going to answer that. I don't know when it was, before or after he testified. But if you're under subpoena, you can't talk about the case. You can't talk about your testimony. You can't do interviews, things like that. If you are released from your subpoena, you can. If you're under subpoena, you can't watch the case. If you're released, you can. If it's before you testify and before the trial happens, you can. You can talk to people about the case. You can do interviews. Is it always wise? Probably not, but you can do that stuff. And we're going to talk a little bit about, so each side has to release you, but I want to play the clip from court today to explain that a little bit more. All right. So on direct, I thought it was pretty straightforward. She's a family law attorney for Doug. She wrote a letter to try to get into contact, see what was going on. They didn't know that the baby was born. Temporary injunction filed by Ashley was denied. She explained some interactions with them. She was surprised how nice they were to each other. She told Doug Ashley was setting him up, which I didn't think was appropriate testimony. Then this was an interesting part. Ashley signed the agreement that this lawyer drew up, giving more of a timeshare for this victim, Doug, to have with the child. So if her grand plan was to keep Doug away from the child, why would she sign this agreement voluntarily? Like you want to see a knockdown, drag out battle, which this lawyer said this was, go look at the Adelson case. They weren't giving an inch. They weren't signing any agreement extending more time unless there was some kind of quid pro quo. And we're supposed to believe that Ashley Benefield, this, mastermind who really wanted to take Doug away from the kid away from Doug, would sign this agreement giving him more time. And I know people are going to start saying, like, Peter, it feels like you're leaning towards the defense. What's making me lean that way is I'm thinking about the case through the lens of the prosecutor and what you told me as the prosecutor and your motive and your theory. And when you present evidence that doesn't line up with that, I start to have a problem. The defense doesn't have to say a word. If you're inconsistent and you don't prove your own case, it doesn't matter what they say. So you always start out on the side of presumed innocent, or I should say I do. Then I'm pretty sure, and Darling said, the way I heard the testimony is that Ashley filed for divorce. I thought the defense told us Doug filed for divorce. I could be wrong. I could have missed it, but that's what it sounded like to me. She said Doug was never angry, was always just matter of fact. What a great guy he was, which he may have been. I don't know him personally, but it was weird to me that she was able to just kind of talk about his personality like that. The defendant kept objecting, saying she was editorializing as a lawyer and not even answering the question, just going off on a narrative. She didn't seem to like that. She even kind of rolled her eyes and looked at the jury a couple of times, which I was like, okay, they're going to battle when the defense lawyer gets up to cross her, and battle they did. We're going to listen to a pretty big chunk of that. The defense started out and said that she has a duty to disclose if any false statements were made and reads these legal rules. Then they go to lunch, and after lunch, the judge is like, yeah, you're not going to be able to ask her if she violated rules. What he was trying to get into is they answered certain discovery, I think, in writing. then in his deposition, the defendant admitted to certain things. And I think they were the aggressive, violent types of things. And she, as a lawyer, never wrote to correct the record, the public record in a family law case. And the judge did not allow him to get into it. I think that one could have kind of gone either way. Then we're going to listen to them kind of start arguing with each other during her testimony. And I do think, so I thought she was fine on direct. I think she scored some points for the prosecution. On cross, it got very heated. And there are two kind of ways to look at this. And I kind of felt both of this during the cross. I want to know what you guys felt listening to this cross, but that she seemed a little too invested in this side, which I can understand. If you have a great client that you really care for and you think somebody did this to them, I can understand that. But she argues them a lot. I also think the lawyer got lost in asking her for so many different hearsay statements that were obviously hearsay that the judge just kept sustaining. And at one point, the judge has to tell him, relax, I just sustained an objection because are you not paying attention? It was not a great look through cross, but I also thought there were parts where I was like, this witness is pushing a little hard. So I want to know what your guys' perceptions were when you were listening to it.
If Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, would we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And
for most of the cross, it definitely seemed like she knew the case better than him, and she was getting him on a lot of these dates. And she keeps saying, I think you're confused, and kind of win those battles. But there were a couple important ones that he won.
Your testimony then that the hearing would have taken place.
Had he been alive, yes. On the 30th, not the 23rd, which is what I think you're confusing.
You refer to a letter that you sent to Ms. Benefield.
The big discussion is whether or not the hearing was going to take place, where the information that was given in the psychologist's report was going to come out that Ashley wanted to hide, didn't want to be made public, didn't want Doug to hear it. That was the big question. Was that the hearing she was trying to prevent or avoid, where she did this deed 3 days before that?
14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it? Okay, this is not the letter that I sent. This is a draft of a letter.
Mm-hmm.
The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on
So again, she gets him there with that little battle.
15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify that there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she...
Nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. That was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to have a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection, that would help if I could see it then.
So they kind of go back and forth a little bit. But did I miss the part where she said, hold on a second. Let me back it up a little bit.
Stay. Got it. All right. So is the answer to my question yes?
Can you repeat the question?
Last question back.
Here it is.
Go ahead, ma'am.
I screwed up the timestamp, but this was one of the quotes I wanted you guys to hear that she said. And she slipped stuff in like this and really pressed to make sure to get info like this in.
And you still maintain after reviewing that the hearing was set for the release of Dr. Broder's report?
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
Okay, actually, I did play it. I just played it twice. It was 3 days after your client killed my client. She made sure to slip that in. There were remarks like that and quotes like that slipped in multiple times. I am going to jump ahead to kind of their next little battle where she starts talking about how she believes Ashley Benefield misused the court system and things like that. Again, slipping more of these remarks in. We're going to listen to 9 or 10 minutes of them going back and forth on the different things that happened.
Which was not said on that day, correct?
I mean, the 23rd, which is what they're talking about in this email. Yes. Right. It was not said on the 23rd. Dr. Broder was on vacation.
Okay.
It was going to be said on the 30th.
Did you know whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay. So after the judge ordered no contact, he sent her a package.
They're trying to get into the fact that he violated this no contact order. So even a judge's order was not going to stop him, just try to make him look like a bad guy. But this lawyer's just going to try to continue to argue with him about it. And she has some points that she makes, but it's definitely a battle back and forth.
My understanding is that Doug did not really understand what was going on at this hearing. And Ms. Benefield was even chastised.
Her understanding was that Doug didn't understand what was going on in the hearing. Not a great answer.
By the court for manipulating that system.
Well, thank you for adding that.
Dang it, I messed it up again. All right, I need to shut up. So this is where she says Ashley was manipulating the court system.
Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank you for adding that.
Ms. Benefield was chastised by the court for manipulating that system.
Let me just ask you a question. What is it about you may not contact Ms. Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it. So enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there. So that's just what I was told. And we had the time that he received this order from the judge from his attorney's office. And it was after he sent the package.
Okay. So this report by Broder, the one that you acknowledge and the state suggests is the theory behind the homicide, Ms. Benefield.
They let him get away with that without an objection. This big important report that was coming out at the hearing that, everybody says is the big deal and kind of the motive and the theory in this case, right? He leads up with that question. Nikki, I agree with you. There's a lot of objections from both sides in this case, and certain parts of the trial have been hard to keep up with and follow without rewinding, and the jury can't rewind.
Had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in family law court. So I don't know what she signed.
She voluntarily participated.
I don't know. You're going to have to talk to the Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer.
I mean, if you both signed something that you voluntarily agree to do, come on. I don't like this type of quibbling personally.
For Mr. Benefield, was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in a family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
Why the quotes? The answer is no. If you were never ordered by the judge and there was no signed order, there's no order. You weren't ordered to. You just answered the question.
You're not aware of any commandment that either Mr. Benefield or Ms. Benefield participate in Dr. Broder's evaluation.
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
Give me just a minute, Ron. Shot at this.
Can I see the document?
Document have any impact on your position? Does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because
I'm going to back this up so we can listen carefully to this, because I think the defense attorney struggled a little bit in this cross, was a little clunky. He lost a lot of objections. But this, to me, if the jury caught it and was paying attention, again, I had to rewind it to listen to it twice. So I'm not calling them stupid. I'm just saying I have an advantage. We all have an advantage they don't have. So here's the big ticket. He just handed her something. I don't know exactly what it is or what it says, but he's like, do you still believe that that report was actually going to come out and be part of that hearing on the 30th, 3 days after the shooting happened? And let's hear her explain it and what was actually happening on the 30th.
The release of Dr. Broder's report was scheduled for September 30th.
it was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you
Is the answer to my, well, let's get a simple answer. Is the answer to that yes?
I don't have the docket, so I guess the answer is I don't know what the docket says. All I know is it was scheduled for the 30th.
I'll tell you what. She is a very, very smart person and witness, probably a good lawyer. She has been meticulous. She corrected this lawyer and knows the case in and out and knows the dates and knows when she sent letters and knows what happened on this day and that day and what each person said and what their demeanor was like. So am I supposed to believe now that she needs the docket to tell me if this was actually part of the hearing? Because if there are multiple motions we're going to deal with at a hearing, usually we can tell that. So let's listen as this continues to develop to where we really feel what was actually on the record that was supposed to happen on September 30th. By the way, like the thing that's mind-boggling to me is like this whole thing was already jointly agreed to. So why are we even believing that she's scared it's going to come out, so scared she's willing to do this kind of a deed?
You trying to make sure.
All I know is that that was supposed to be addressed on the 30th of September.
And were you not told on the 30th of September that the only issue that would be heard was the domestic,
asked and answered.
was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was.
He's like, September 30th was to deal with this domestic violence injunction, was it not? So whatever he handed her, I assume, said dealing with the domestic violence injunction, whether it's the notice of hearing, whether it's an email, like this is what we're going to argue on September 30th, not this joint psychological report mutual release. So that's pretty big, because if she wasn't hiding from and afraid of that September 30th hearing, then what's her motive of doing it on this day? Except that she was in fear for her life. If this is true and what's getting across, you guys tell me, are you seeing the same thing I am? Because if the jury missed it, then it's not effective.
Was not the case by the time we got to mediation. The situation had changed.
Yeah. And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong, and that
Compound question?
and that the only matter being heard was not the domestic violence injunction?
Sustained.
Do you have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide
Do
emails.
you have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew
emails.
what? You knew you were coming to court.
See, these kind of like little sneaky answers, these dancing answers, trying to, not get hit with these questions. I didn't bring any of the documents. I wasn't told to bring any documents. He's like, are you being intellectually honest with me? And I've had witnesses do this too. It's like, do you expect me to believe that you have proof of this and you just never provided it as a lawyer?
Or to testify before the jury in a homicide case.
Objection, badgering.
That the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us? That's all.
I disagree with the judge sustaining that. I think that's a perfectly reasonable question. I think that answer shows a lack of credibility to me. The state does not have a redirect. When the judge and everybody asked if she can be released, the state said yes. The defense says absolutely not in front of the jury, which is probably technically inappropriate. You should not add those qualifications. You should just say no, like he said with a lot of the other witnesses, even though usually he says yes, sorry, no, but that's okay. And then the judge explains, and this lawyer's like, I was never served by them, judge. So I shouldn't have to be under subpoena because I wasn't served by them. You have to do that in the proper timing. And the judge, I think, kind of came to the defense of the defense here, which I found interesting and kind of surprising. And listened to him explain it to this witness, how it works here in this courtroom.
Is of no moment to me. I asked, should you be released from a subpoena? The state said yes. The defense says no. That's all I need. So, Ms. Murphy, you are not released from your subpoena. The obligations regarding the rule of sequestration and full statutes.
All right, I want to hear the whole explanation from the judge.
My position is when a witness is subpoenaed to court, and the reason I ask each and every time, can this witness be released? Because I believe witnesses are subpoenaed by the attorneys on behalf of the court. So whether
he believes the court is subpoenaing witnesses, not all judges agree on this, but he's saying if you're here, it's because I'm saying you got to be here. So if either lawyer wants you to stay, I'm going to tell you you're still under subpoena, and the court has the power to do that.
We're subpoenaed by the state or the defense is of no moment to me. I asked, should you be released from a subpoena? The state said yes. The defense says no. That's all I need. So, Ms. Murphy, you are not released from your subpoena. The obligations regarding the rule of sequestration and full statutes applies to you. Thank you.
Thank you.
All right, the witness has been excused. Mr. Taylor, you wanted to approach, but the jury's out, so I figured might as well just take care of it now.
Sure.
So now I want to hear this lawyer wants to make some arguments about that lawyer.
So now I would ask that the court issue a subpoena to Judge Moreland's clerk. The court may recall that we had an in-camera hearing where the court quashed the defense subpoena to Judge Moreland's JA and told me that there were better ways that I could prove my case and that the court shudders to think what would happen if every JA were subpoenaed. What the court's just witnessed is Ms. Murphy lied flat out about the reason why Ms. Benefield feared release of that report. And
he said, with no words held back, and Belinda seems to have felt the same way, that Ms. Murphy lied. And that hearing was not happening for that reason 3 days after. And so the whole motive falls apart. And he wants to be able to get into that, to call the clerk to say, what were you guys dealing with at that hearing? The domestic violence injunction, not this report.
Impeachment of Ms. Murphy indisputably is going to come from Judge Moreland's JA, who told Ms. Murphy in the emails that I handed her and showed her, the only thing that is set for hearing on September 30th, 2020 is the domestic violence injunction. Nothing else will be heard. In fact, I'm going to read for the record. I'm going to read the one sentence email that was sent.
The reason I'm going to stop you at this point is you're referencing arguments that were made in camera. The state was not present at your request in order to preserve trial strategy of the defense.
So he basically says, we had this in-camera hearing. The state knew about it. It's different than YSL because they told the state about it. The state knew about it, and they had a good reason to do it in camera without the state because it was defense strategy. So, but in order for us to have this whole conversation, the state needs to go. So he unseals everything that happened. The state gets to look at it before we kind of finish this argument, but you see where he's going with it. Next is Officer Gillum, who basically says Ashley complained that the injunction was violated. He doesn't really seem to believe her. She asked him to arrest the victim in court in front of the judge. It was a weird request. He had never gotten that request before. And so he found it weird. And then on cross, the defense lawyer is just struggling horribly to try to ask these questions, continues to get objecting to hearsay. I want to show just a little bit of it to show like sometimes this can affect the trial. And I've had jurors come and I've interviewed jurors after trial. I just interviewed a juror recently that sat on a different trial. And he was talking about how unprepared the lawyers seemed. And it was just hard to follow the case and even go with them because of how unprepared. I'm not saying this lawyer, I think, has done a really great job at times and then struggled through other times. And this was just a kind of a part of a struggle.
any other agency to this package that was sent to Ms. Benefield?
Objection, Your Honor.
Sustained.
Did you tell Mr. Benefield that you would be able to unfound the case if he sent you the receipt?
Objection, Your Honor.
I'm asking him if he told
Seriously.
Mr. Benefield.
Please approach.
Did you tell Mr. Benefield?
Can you please approach? Can you please approach the bench?
Sorry.
He like has to say it 3 times, please approach, please approach, please approach. I don't know if he didn't understand or didn't hear or whatever, but not his greatest moment, obviously. And this stuff happens in front of the jury. And what does the jury think and feel about it? We don't really know. We don't always know. But I like to get a gauge of what you guys are thinking and feeling about it, because that's usually finger on the pulse type of stuff. So then we get to, he didn't put the stuff about the, Ashley wanting to arrest Doug in court in front of the judge in his original report, but he put it in a supplemental report. The defense made that seem nefarious, like he was trying to pin something on her, making it up. I think the state did a good job unwinding that on redirect, and then it just kind of got crazy here at the end of redirect.
When he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So
he just thinks she's having a meltdown because she's not getting her way with him. Shows you kind of what he thinks about her. And again, the jury's seeing all these professionals, CPS, cops, nobody believing her about her complaints. How are they going to look at that? Are they going to be like, we're going to be with all these guys? Or are they going to be like, oh, they were mean to her? How's the jury going to view this? We'll see.
At that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time. And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying, I'll do whatever I have to do to keep my baby, you a-hole, as.
So he didn't take it as a threat at the time, but now he takes it as a threat.
My manipulation attempt for the court system, not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats, but I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown. And there was just no reason for me to put that in my supplement that she was having this massive meltdown because I wasn't going to buy into it.
And so after
he wasn't going to buy into it.
She murders Doug Benefield, you thought it was relevant.
I thought that was very relevant information. I needed.
And then the state in that question says she does that to Doug Benefield, and then it became relevant. No objection, came in front of the jury. Jury hears it.
And did you reach out to someone about that? Or did they reach out to you?
I reached out to them.
You reached out to Detective Warren, correct?
Yes.
Okay. Thank you. No further questions.
Did Detective Moore direct you to write this up?
Absolutely not. I wouldn't take orders from him to begin with.
And
he says, did Detective Moreland or whatever tell you to write the supplemental report? No, I wouldn't take an order from him to begin with. That's what he says.
2.5 years later, you remember that she said specific things. This will help me keep my baby if the judge sees you arrested, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Okay, can you be released?
So he did wait. He did 600 other cases before he came back and uploaded that report. Sometimes it happens. I don't think he shied away from it at all. He's like, absolutely, that's what happened. Then Moreland comes up and testifies. He dealt with a bunch of complaints, investigated them. Nothing really came of it. So again, another person in line with what the state said, that all these other professionals didn't really agree with her, didn't really believe her, things like that. Before we get to the next witness, let me answer some questions. When a witness is obviously hostile towards one side, does that take away from some of their effectiveness with the jury because of bias? I always think it does. And if I'm prepping a witness, I'm like, make sure you don't go too far. Just be honest, answer the question. There's going to be some bad stuff that comes out. There's going to be some imperfect answers. That's life. We're going to deal with it. We're going to explain it away. We got to tell the truth. But when you push too far, sometimes you can lose credibility with the jury. Peter, I'm an RN in New York that wishes I had gone into law. Do you use nurse consultants in your firm? We have before on some nursing home cases, not a ton. I want to get into this field, even just per diem. I encourage you to do it. And if lawyers do use it, jump at it. I think it's cool. Who claims stand your ground but refuse to testify at stand your ground hearing? I find that bizarre. So people have done that. It's not that unusual, actually, especially if you know a judge and you think you're always going to lose, just save it for a jury. A lot of times lawyers trust juries more than judges, especially in situations like this. So it's not as uncommon as you might think. And Mandy followed up with, to be successful, don't you have to testify and tell a judge your side? Ashley refused. I don't think you have to. I think it definitely helps. I think it's the more common strategy. and I would say it's more often a successful strategy than not testifying. Chris, regarding the defendant not talking about the incident in Rittenhouse, didn't the judge get pissed when the prosecution raised the defendant's silence? Is it similar here? I think it is. I would tell them, I would probably say, no, you can't ask that or talk about that. The fact that she remained silent, but technically it's your right to remain silent with officers, not necessarily your friends. But yeah, I think it is similar, not exactly the same, because in Rittenhouse, I think it was more connected to law enforcement. How can you have asked and answered when the witness never actually answered the question he asked? Because sometimes judges forget, they hear and remember that the question has already been asked, and so they assume it's been answered. But you as the lawyer have to say, Judge, they never answered my question. I've had to do this. I've made this exact argument you're saying right here, Tara, where I'm like, Judge, I've asked this question 3 times. It hasn't been answered yet. They keep dancing or not answering my question. Absolutely. The prosecutor's irritating me with the interrupting objections, displaying her annoyance, frustration, so unprofessional and distracting. Alexis, somebody literally just said this about the defense attorney, and I was like, I do feel like it's kind of going both ways here. We're not going to get this video in under an hour, which I always try to do. John said, so how did the dancer supposedly commit this crime? New. So I'm going to do a case-by-case summary for a minute. At some point, I was supposed to do it today. I'm not going to have time to do it today. Hopefully tomorrow. We did the full opening statements. Basically, they're moving. The defense says he bumps her and kind of gets forceful with her. The state says it was just a normal moving day. She shoots him. And then the jury has to figure out, was it self-defense or was it not? Melanie, this whole day had me bouncing from one side to the other. Doug may have been a jerk, but she made too many complaints without living with him. Maybe why DV cop didn't believe her. The older women on the jury may just hang this jury. So bouncing back and forth usually is not a good sign for the prosecution, especially during their case in chief. But I appreciate this analysis here. Okay, we're going to jump to the psychologist, Dr. Broder, who has done the infamous report everybody's been waiting on. He definitely confirms that Ashley presented differently with him in front of Doug and when Doug wasn't there. But, I mean, we're going to listen to him explain this. You guys tell me what reasons you think he believes Ashley presented differently in front of Doug and not in front of Doug. Was it because she was manipulating Doug? Was it because she was afraid? Let's listen to how he explains it.
And that they were moving all together as a group.
This is the prosecution's witness, prosecution's questioning him.
Intention of moving together as a group. She had every intention of moving with her mother and Emerson and becoming situated in her, her grandmother had passed away and the mother had inherited the house. So they had their residence established. So she had that plan.
Okay. And so I guess I wasn't being very clear. Were they moving their items together, like same U-Haul truck?
No, absolutely not.
Okay. So Ashley never told you about that?
Quite to the contrary, she made it clear that she did not want him to move in, regardless of what he thought or whatever he was planning. That was not part of the plan.
Okay.
And he wasn't hiding it. That wasn't part of the plan.
When she was alone, she would indicate to you those things that you just described? Or did she indicate that when she was with Doug?
When she was with me during our individual meetings.
Okay. When she was with Doug, how was her demeanor? How was her attitude about those issues?
She would basically respond in a very deferential way. She would let him say what he wanted to say, but my focus was not so much on what their future plans were.
She responded in a very deferential way when Doug was in the room.
They weren't even officially divorced. My focus was, again, getting back to the point about the best interest of the child. Child protection team is, how do we get this family out of this stressful situation and then create something that's going to be better for Emerson?
Okay. Did Doug, during your joint sessions, did Doug express in front of Ashley that his hopes that moving forward this was going to be an attempt at reconciliation? Did he express that in front of Ashley?
Yes, he did.
Okay. Did Ashley ever correct him and say, whoa, wait a minute. No, we're not doing that.
Not really. I think the closest she ever got to that was to kind of say, just kind of slow it down and, we'll talk about that later. And that's, that kind of thing. She would kind of deflect attention away from that.
Okay. So she would deflect attention away from that. I mean, that does not sound unreasonable to me. That does not sound unreasonable to me. She did say at some point she was running out of time to move to Maryland. She said it was taking too long. She needed to move on with her life. Again, seems like a victim speaking to me. She complained that the agencies were all getting it wrong and not protecting her child. That's what the state said. And the state would use that to say, that's because you're wrong and the state just doesn't believe you and that's your fault. He keeps saying all she cared about was moving on. But then the prosecutor's like, did she say anything interesting at one point? And this is what he responded with. Obviously this was kind of prepared ahead of time, which there's nothing wrong with, but that was the trigger is, did Ashley say something interesting at this point?
To get a court order to release it. And that that's usually what happens. It's kind of a formality, but it's no longer something for me to share or divulge.
Okay. And did she have a reaction to that?
Her reaction was that she felt, again, very frustrated, thwarted in her efforts. She wanted to get on with her life, and she felt she needed to know what was going to be recommended so she could move on.
Okay.
So Ashley was manipulating every situation, Sienna said. And I see some people doing this, and that's fine. I'd be open to discussing it. And, hopefully we get a little more information about that. But so what's the point of her manipulation? Why did she allow him more visitation with the child? Why did she sign this joint agreement for the psychological testing to be released? Why did she tell him that she was moving to Maryland? Why does she, keep him involved in so many different ways, allow him to come over to the house to help them pack the U-Haul? Like, she didn't need to allow any of that. Legally speaking, if he was, battling to get custody and she had to allow him time with the kid, okay. But she didn't have to let him come help them move. It's just so strange to me how all of this happened. I don't get her manipulation if that's what she was doing. I don't think she was I was going to be maybe a little too far to say she wasn't good at it, but I am not, it's hard for me to follow exactly her motives and actions and what she was doing.
And during that conversation,
So Mandy, it's way too early for a poll. We don't poll usually until after the defense rests their case. Maybe sometimes after the state prove their case, then after the defense, then after closing sometimes, but it's too early for that now.
Anything that struck you as interesting during that conversation with her?
Well, she had explained previously and then repeated it then that once she was able to relocate to Maryland, she wanted to establish residence, that she had, in essence, researched it, knowing that if she had established residence for at least 6 months, she could then appeal to the authorities in Maryland to get relief and have Emerson, basically have full custody of Emerson and not that. So she had used the phrase during that conversation that she would take matters into her own hands.
Okay.
So she would take matters into her own hands, and she had a plan to move to Maryland, where I guess if you're there for 6 months, you can petition the court and have a better chance to get full custody of Emerson. That sounds like a non-lethal plan to get custody of her daughter if that's what she wanted at the end of the day. And I see people saying the chat is divided, and I think that's fine. And I think that breeds good discussion. Let's keep an open mind for each other that see this case differently. And let's see what the evidence actually points to, okay? Noelle said to keep him happy. But if she was manipulating him and this was her end goal always to end his life, why was she trying to keep him happy? Belinda said she was placating him. Been there, done that. Right, like afraid of him. And then if he snapped and did something physical, that's why it escalated to where it would. I think that goes more in line with the defense's case than the state's case. Bethany said still using his last name 4 years after his passing and despite supposedly wanting a divorce before that. Legitimate reasons for this or tactic? I have no idea. Like, what would I advise a client to do? I probably wouldn't comment on it. It's a personal decision to me. Deferential deflect. That sounds like fear to me. Reese's mom, that was my first inclination as well. Yeah, in a respectful way. Like, what do you think she's doing that's manipulative? I would like to read it too in the chat. Okay. So the defense picks up on the fact that he's saying placate and deferential and all that stuff, and they focus on it as well on cross-examination. So let's listen to some of that. This is the defense crossing that witness.
So I think you told us, Dr. Broder, that this policy of appeasement was designed by Ms. Benefield to basically placate Doug Benefield.
I think I'd use the word strategy. That was her idea of trying to...
Yes, to placate him. In other words, to not set him off.
She knew that he wanted to reconcile, so she wanted to kind of, I think, feed into that so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
Did you acknowledge during the course of these evaluations that the signs were there, that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
Well, let me ask you this. Did you consider that Ashley's position was that Doug was only interested in her and not in the child.
I certainly considered that, yes.
And that was Miss Benefield's position, was it not?
That his sole aim was to win her back, yes.
So, I mean, that's interesting too, as far as protecting the child and maybe not wanting him to be with the child just because if he was just after her and not the child. But regardless, at the end of the day, he basically says there were issues, right? And I think that was obvious through a lot of these witnesses is that there were issues between them. And he also, at the end, the defense attorney tries to slip in there that 3 different sources made complaints. 2 of them were professionals, objection sustained, but the jury heard it. On redirect, the state got up and did a good job saying, explain to me what a mandatory reporter is. So basically, if Ashley Benefield says anything to anybody that's a mandatory reporter, they have to report. So those complaints or reports aren't necessarily legitimate, which I thought was a great job by the state. The bigger issue is what Doug Benefield has already admitted to, but they did a good job playing down some of those complaints we keep hearing about. The next one is Dr. Jason Quintal, who is a mental health counselor, trauma resolution, expert, treating them for that. And he kind of explains what the dynamic was between the Benefields.
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into specifics, but
Ask the question. He's entitled to complete his answer.
The defense is like, let him answer the question. But he'll have an opportunity to cross him to let him answer those. Make sure you guys hit the like button if you haven't already. We're at the 1 hour mark. We're almost done. I usually like to keep it at an hour. We're going a little bit of overtime today. So hit the like button for overtime. And if you want to continue us following this, and make sure you guys subscribe. If you're new to subscribing from this case, let me know in the comments as well, please.
so did she indicate she still wanted to reconcile with him when she was with you alone? Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Okay. Did Ashley tell you that she and Doug were also seeing Dr. Broder?
They both mentioned that Dr. Broder was doing an evaluation, and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge, that didn't go her way. So I think there was definitely some discouragement with that.
Okay.
That's about as good of an explanation as you can get if you're the defense, not the state, that, she wasn't getting her way. Well, she was discouraged that I honestly, if I'm being honest here, I'm a lawyer. I do this stuff. I ask these questions. That didn't even pop into my mind. That maybe it was just she was discouraged. People weren't doing anything, as opposed to maybe what the state's trying to pitch that everybody's against her. Nobody finds her credible. That's kind of where my mind was going. But then this guy's like, well, she was just discouraged and nobody was listening to her. She was crying out as a victim and nobody would help. So she was frustrated by that. Pretty good explanation. Again, state witness, state question, and that came out. Just not great. This guy just seemed pretty credible to me. He was just answering it down the middle, whatever he thought the answer was.
And, I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was taking for Dr. Broder's report?
Yeah, she thought that was taking a very long time.
Okay. And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried.
So this is what the state was, their big theory, right? She's worried about that report getting released. Listen to how he explains her fear of the report getting released.
That she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay.
State witness. Yes, she was afraid of that report. Point for the state. That's her motive. Minus 10 points. What she was afraid of, that if any disparaging remarks came out about Doug, he would respond and seek retribution and get upset. Not great for the state.
The last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day the week?
I'm going to jump ahead a little bit to where we get the interaction between the lawyer and the judge after I hit a few questions. Peter, did Doug hit a dog or not? The state has said yes. I think, we have to wait to see if it actually comes out. Sorry, the defense has said yes in their opening statement, but we have to see if it comes out in evidence. If we don't know she was in fear, then that is reasonable doubt. If we don't know she was in fear, is that reasonable doubt? I'm confused at this question. I'm confused at this question. Amy, why did they marry each other in such a short time of knowing each other? Is she from the USA? Green card? Yeah, no, they're both from the USA. And that is a little bit strange. I wouldn't recommend it. It can work. I wouldn't recommend it. But what I will say is both of them made that decision. So you can't really hold that more against one of them than the other, right? Mandy, the only way to get the baby out of the state is to let him know. Otherwise, it could be kidnapping. Could that be why she told him? Could be, depends on what they need or mean, but seems like she was telling him everything, right? He knew she was in Florida. He knew she was moving to Maryland. She was moving to Maryland to try to get custody after 6 months. Like, I just don't see, I don't see the urgency to take this step if it's all part of her plan. It seems like something had to happen that night. Maybe she got pissed at him. Maybe she was, worried about this report. I think that's why the state picked that motive, because that's the only really thing that makes the timing make sense. All right, so we're going to jump ahead about a minute on Cross, where he starts asking questions, and then there's an objection. It's sustained, and the witness goes something like, and the defense lawyer's like, yeah, you have no idea. And the judge is pissed.
Okay.
Cross.
Afternoon, Dr. Quintel.
Hi.
How are you?
I'm doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Sustained.
So the reason that's sustained is because it's hearsay, but if he's an expert, he should be able to comment on some of that, and some hearsay can still come in, but that is so damning for the state. And the jury heard it. She was concerned at that time meeting with him because of prior acts of violence. So if that's in her head and that's her psyche, subjectively speaking, she is in fear because of what she knows to have happened in the past. That's evidence coming out. Maybe there'll be more evidence of her being a master manipulator and manipulating him in every situation. And if there is, I'll try to point it out and we'll try to discuss it together. But, I mean, the jury heard that. So now is where, after this objection gets sustained, he makes a facial expression, then listen for the lawyer.
Is prior acts of violence, shooting a gun, no.
Sustained.
Okay, without? Yeah. Oh, you have no idea. Without.
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out? Remember, please don't begin your deliberations. You can't use your.
Immediately, the judge is like, send the jury out. Send them out real quick. That's the scariest tone somebody can have, because they're bottling it up at this point, which he should do. He should not ream him out in front of the jury. So I respect the judge for that. I do think this judge maybe went a little bit overboard with, everything that he did, and the lawyer knows it's coming. He doesn't seem to care that much. He should not do that, by the way. You should not say things like, oh, you have no idea. You should not comment on objections, whether you win or lose them. You should not give any indication you're frustrated at the court. It doesn't look good in front of the jury. It doesn't help you. So all that is the case. And I don't think the judge is wrong for reprimanding him. But the judge, really makes a big deal about this.
Phones, but don't talk with anybody outside of the jury. And don't do any research on the people, places, things, or legal topics you've heard anything about.
Yeah, Bethany, no big deal. I love the question. And a lot of people have put answers in, like the last one I just put up, of different reasons to keep the last name. I love questions. Every question I like. And I don't take any slight from
you to the hallway.
Okay. Take my stuff with me.
Yes, sir.
He goes to the hallway. A reporter comes up, tries to give him a card, and he's like, no, I don't want that. Which I thought was interesting, because the judge instructs him, you can't talk to anybody now.
Attorneys.
Thank you.
And before he reams the lawyer, it's almost like a cop who pulls you over. Do you know what I pulled you over for, son? That's basically what he asks the lawyer. He's like, you want to say anything before I start?
Thank you.
Mr. Taylor, is there anything you'd like to share before I do anything?
I think I'm about to catch a whooping.
He said, I think I'm about to catch a whooping. That's what he says. I found kind of funny. And again, I respect the judge, because at least he's doing this outside the the presence of the jury. The jury probably got no indication that he really got too mad about it, hopefully. And whatever he's going to say now is between all them. They're all professionals, and he should reprimand the lawyer and tell the lawyer, if you think he went a little too far, okay, I get it. I think there's a range of possibilities. I don't think the lawyer was really offended by it, but let's listen to what the judge says to the lawyer now.
I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process.
Seems very unbothered to me, which most lawyers like him, 400 jury trials, criminal defense attorney, they are used to getting beat down and yelled at and people not liking them and losing trials and having hard cases, getting some big wins, that this doesn't faze most of the lawyers of his ilk, I would say.
And procedure that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's in.
I heard some people saying he said the defendant's guilty. He said if she's convicted, which he's right, if she's convicted, he can appeal every single one of these decisions. That's how you do it. That's the respectful and appropriate way to do it.
Will have every right to appeal to the Second District Court of Appeal every decision I've made from the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break. I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well for the.
Imagine how brutal that is. Youth sports umpire, woof.
Criticism that comes with the job. However, those sorts of side comments are just, they're not appropriate. And I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right, so we'll take a 5-minute break. And
I actually kind of like overall what the judge said. I like overall. Was it, a little overboard or a little bit more than necessary? Maybe. Overall, I respect it. I agree with it. He's right. He had a very respectful tone. He didn't scream at him. He didn't sun him and tap him on the head. I don't think too much. Overall, I'm okay with it. This lawyer knows probably you shouldn't do stuff like that and have those kind of interactions in front of the jury with the witness. Defense lawyers get away with a lot more than prosecutors or plaintiffs' lawyers in civil cases. So, I get what's going on. I read a study Brooklyn Basement said on how age and gender of jurors affect the trial outcome, suggesting she will have a better chance with older female jurors. Would you agree? Yes, generally I would agree. It's not a perfect science though. BB, redo it seems backwards, but state has to prove she was not abused in fear. If the jury is not sure, then reasonable doubt, not guilty. Yeah, if they think that she was probably in fear or maybe in fear, yeah, that's not guilty. Sorry, I didn't understand it the first time. Okay. So then this witness gets back on the stand basically before they end the day a little bit early and basically says he questioned why both of them stayed in the relationship, not just one or the other. And that's basically the end of the testimony for today. And I think based on the state's track, they're going to be done tomorrow. Maybe this case will be done by Friday. Rebecca says, this is why you don't disagree with a doctor in front of a patient, in my opinion. However, has it ever happened? Oh, I'm sure it's happened, but yeah, I agree with you. Generally, you want to keep it as respectful as possible in front of the jury, in front of patients. I got to run though. I've got some plans tonight. You guys are the best. Thanks for being here with me. Make sure you hit that like button. Make sure you subscribe before you leave. Let's get this one to 15,000 likes too. You guys are the best. I'm going to keep following this trial. It's really interesting. It's got me hooked now. Let me know if it's got you hooked too. Until next time, let me get Belinda here. I could never be on this jury because in all honesty, the prosecution lost me with the animal abuse allegations and the firing of the gun in the ceiling. This man was an abuser. These people don't stop. Survivor. I got to be honest. I think these are going to be huge factors for any juror, not just you, but any juror. All right. You guys are the best. Till next time. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.
Oh, thank you, Peter. Thank you for entertaining everybody over the lunch break. Let me get the court back up now then. Oh, hey, Katie. Santos, hello to you. How are you doing? Sea-Dog. Oh, shit. Sea-Dog's gone. See you later, Sea-Dog. We've gone, so. Why is a Lawyer You Know one? Oh, Dottie. Dylan's just replaying it over lunch. Sub to the hotness that is Tragos. Look at Erin Hack. You little minx, you little fox, yeah. Erin's on a hat. On heat. Vicky, I think I need a shower now. I think a lot of you probably need a shower right now. How's dinner? I've just cooked it. I've not eaten it yet. I will be eating it as soon as they come back. I've made it, but I've not eaten yet. So you'll see me disappear from the screen as soon as they get back into the groove of it. But it's all good. It's about now. I like to eat my dinner. It's too early. It's 10 to 6. Well, 4:45 here in the evening. It's too early to eat. When he broke, it was like 4:30. I was like, I'm not eating at 4:30. So, Stormcat's back in. How we doing? Keep it moving. Hang on. Hang on. Let me just do this. Okay. Right. Beautifully Inappropriate. Dell's back. I am back. Guess who's back? I am back. Let's fucking go. Beautifully Inappropriate. Amy Lynch. Hi, Delan and Char. Hope everyone's doing right. Hello, Amy. Now, Amy, forgive me if you've been here before, but I'm not sure if you've been here before, Amy. So forgive me if you have been here before. I just don't recognize you there. So forgive me if you've been here before, but I believe you're probably a new chatter. Correct me if I'm wrong. But hello, Amy. How are you doing, my darling? Hope you're well. Vicky, there he is, the fox. To the fox. Yeah, I mean, hey, go and shower. Don't worry, I get you. I got you. Hey, Vicky. Hey, TJ, nice to you come back. TJ was brand new yesterday. And look, oops, Amy's brand new today. So we got 2 brand new people. Hey, Amy, welcome. Where are you from, Amy? If you're from the States, which states are you from? If you're from the UK, whereabouts are you from? Nice to see you, my darling. What time is it custom for dinner? About 6 o'clock. Roughly around 6 o'clock, Steph. You know. What about in Australia? What time do you put the shrimps on the barbie in Australia? Welcome back, TJ. Angelina, finally off work, so I'm back checking in. Hey, Angelina, nice to see you, my darling. As always, lovely to see you. Welcome, Amy Lynch from Josie. My pussy's sleeping now. She obviously likes you.
All right, good afternoon, everyone. We're back on the record. State versus Ashley Benefield. We finished the
Happy days.
lunch break. And before we bring
welcome, Amy.
Deputy Quiles, or Detective Quiles back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Quiles on Defendant's Exhibit 3, which
I will describe as, and it's been told to me that these are from Ashley Benefield's phone. And the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016, and the page numbers are not sequential. That is, it's page numbers 1, 786, 222, I'm sorry, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly state, I'm sure you have these as well, and may.
Well, I guess one of the issues, Judge, is that we aren't being showed anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB texts, but they're not all the same. There's some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over. May I approach? If you don't mind. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the original witness lists were filed in the late June.
That probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the, the defense has 15 days. So, all right, please.
They attended a deposition of Sergeant Quiles where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump, DUMP. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, searching. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed, but at the deposition, I clearly presented these to Sergeant Quiles, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts. I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to the point where there are things being offered for evidence that have never been provided to the state, that I can't even find at the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem we're having. And the obligations are different, as Your Honor knows, and I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not the same.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substantive statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Quiles' deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached to his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone dump. We provided it to them. They listed it and said it's in our possession. So they did not provide us a phone dump.
Okay, so you already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So
I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing. And that also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent, I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so
We can just request that be done before we're in the middle of examining it.
and copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about. That being Defense Exhibit 3. And we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes, court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes. Okay, so we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Ms. Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum, use of discovery depositions as substantive evidence in criminal trial. I also had previously filed on July 10th of 2024, a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The the necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting the hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Can I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Yeah.
Do you mind?
290 Southern 2nd, 73.
And I have one as well. I don't know if they want to hand it up now. I'll read it.
So this is what you just handed out?
Yes.
All right, I've reviewed Henry.
You want me to comment on Britain case that they just provided?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So we don't have, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overt act, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britain case, is an example of that, where there were prior acts of violence, but because they were so attenuated, They were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britton's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call and testify a domestic violence expert. That domestic violence expert is going to educate the jury, in fact, he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved,
because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse. And you begin to develop a survival instinct for it. So that's why you employ the get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal was Ashley Benefield concerned about the release of the Broder report. Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions. Some people call them spontaneous statements. And therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's a issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order. And this is, again, Smith, 606 Southern 2nd, 641. And this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course, we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident, which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing, 577 Southern 2nd, 682. And in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420. And this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it. And I looked at Henry, I was reading Henry that the defense produced to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence and unfortunately it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry, Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the
I guess you can ask, but I'm in the middle of a ruling.
Okay, well, I think it may be relevant, helpful
Okay.
the court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay, so.
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 ball, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt. And in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Thank you. Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness, the rest of what was taken out the iPad.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right. So I just to put defense on notice that may be an issue.
So we're going to bring the witness back in, and you can resume your cross.
So that the court doesn't run the jury in and out for naught. I've shown Suzanne the remaining aspect of my clause, anticipating there may be some objection to it. So,
And I would have an objection.
You do?
Yes.
Okay, can you step back out?
Sure.
Same rules.
Judge,
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, then maybe the defense can confirm. I believe these are supposed Google searches or internet searches for certain subjects that are on
yes,
the
they're
Benefield phone.
on the phone,
And
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry,
2020, Your Honor.
the first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, with a parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Doug Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming out.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Quiles extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
Yeah, I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Broder's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then again on 5/11/20, asked Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project. And 6 tips on 5/11/20 to help you co-parent with an abusive ex. So the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the break. Once the 9/11 tape came in, which said my husband attacked me and I shot him together with the swollen eye and the scratches, as the case law says, I think that may
certainly qualify for the slightest effort.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing a murderous.
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now,
No,
at
that's,
this point.
okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response.
Judge, the reason this should not come in is the exact same reason that you just ruled on the last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason.
Could I please see the exhibit?
Of course. Ma'am?
And the purpose of offering defense exhibit 4A is to prove that Ms. Benefield actually made those searches.
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Quiles went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of
what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone. And the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. We still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Quiles. I would like to make a proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read Defendant's Exhibit 2, or anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Quiles.
Can you just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
But if we could just make a copy and enter it.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, got it. Yes. These are text from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer.
Correct.
Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that
Keyless.
Detective Quiles would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone.
I believe he would, Judge. I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes.
Do you want Quiles to stay under subpoena? Because I want to give him the right instructions.
Yes.
All right, can you have Detective Quiles come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
different.
That's why I did it.
Sergeant, I'm sorry.
Right here over there.
Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. All right. Look, the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
text message,
the What's Now apps, WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want?
Well, I'd like to have it on there because they showed it, but they showed it very quickly.
Oh.
Defendant's Exhibit 5, which is
Yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in.
Thank you, Madam Clerk, for catching that.
Well, it's
right. 5 is in. 3 and 4 are proffers.
When you say, Your Honor, that Exhibit 5 is in, for purposes of proffer.
No, for evidence.
Yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible.
Okay.
Because it was shown. State, you showed it.
Right, it was shown.
So this is just a printout of.
Okay, but I think he hasn't. Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just give the prize.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then. All right. All right, so you ready to call your next witness?
Yes.
Ready to bring the jury in?
Yes.
All right, let's bring him in.
And I think we are going to use the, maybe just.
I'm confused what the hell's going on now. 2 more witnesses left. Let's hope we're done today. With the state, anyway. I think she looks worried now. Oh, I thought there was a hot mic there for a second. Who do you all think that is her new boyfriend then? I don't know who the new boyfriend is. You all alleged might be her new boyfriend.
All right, welcome back. All right, you all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything you talked about? All right. When we were last here, Detective Quiles had finished his testimony, and now we'll let the state call their next witness.
State would call Dr. Vega.
I'm not sure she's got a new boyfriend, Deb. I think everyone's saying that she might have a new boyfriend, but I don't know which one it was sitting behind her. I'm waiting for Hausdorf to tell me.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Hello, sir. I'm Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, to right as you need. Speak in a loud, clear voice. We should hear everything.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. the percentage, you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And I'm gonna draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you the pre-marked states 86 through.
Can I see the photographs, please?
Yes, the same as the ones you just looked at.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
she's gonna put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the length?
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge, just bear with me. Dr. Vega, we're going to try this one more time. I'm going to show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you, Your Honor. At this time, I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them out here in just a moment.
Okay.
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been marked as states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Thanks, sir. And where would the exit wound be?
Well, no exit, but
I'm sorry, the projectile.
projectile,
Yes, sir.
my mobility is limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal.
Yes,
Was it, it wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body.
Thank you.
The
So
spine.
his spine.
Yes,
And would that injury have been immediately fatal?
probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes, what one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said, finally, you said he was also shot in the leg. Is that correct?
That's correct.
So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different
And how so?
because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast moving awl or punch, in that it goes in and it almost drills a hole into the skin. But when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out. And that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Hard to see with the wall here, so.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
So on me, the entrance was here.
If it would help, I could put my finger there.
Okay. And the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left. And from back to front. Yes, largely all three of those components.
Thank you. Well, with Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you states 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter states 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of states. This is states 97. Is that the same item that is in states 15?
Yes.
Thank you. Did you find any, I'm going to go back to well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
Well, the absence it reflects the same principle in either injury. And what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require, the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated, because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
yes,
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell, when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And were there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular. And so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Mr. Taylor Cross, and of course the question is, do you need this?
I do not.
Yes, sir.
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice. Thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct. Yes.
Muscular build.
I don't think I use that terminology. I think I just talked about the weight and the body length.
I want to ask you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3 foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his expertise.
I'll allow it if the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
Objection, close for legal.
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because I've asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would have had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Vega.
State any redirect?
Yes.
Dr. Vega, I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes, so the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Oh, General, we're switching. Could the deputy pass 14 and 15? Would you mind?
Oh, pass, you mean
Yes.
to the jury?
Sorry,
I wasn't
publish.
quite sure what you meant.
Sorry,
Publish.
I meant pass through the jury. Yes, sir.
All right. Members of the jury, as with yesterday, we're to pass these around. These will go back with you during your deliberations. All right, State, your next witness.
Daniel Hausdorf.
Face the clerk.
Madam Clerk, so are you sure what you're saying? Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Hello, sir.
I don't judge.
My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
Hold on 1 second.
Oh, I'm sorry.
Go ahead. You all finish up. So we're going to wait a second.
Yeah, I apologize, Judge.
I don't want anybody to feel rushed. But like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorf. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearms section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say well, we're going to get there. I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases for firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number.
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given a unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case, and everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence where the custody of all the evidence is being held at that time and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials in my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
Yeah, it's empty.
I was gonna say there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorf,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then like the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it will go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Mom. Can we put it for a moment?
Of course.
Mr. Hausdorf, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said. And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLE case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just so we can talk about that part?
Yes.
We're really going. And so you said you first look at test to test, and can you explain slowly
Yes,
how what you're looking for to compare those to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10. And 14. Would you like take a look at these items?
Yes. Thank you.
And tell me if there are items that you've previously seen in your lab.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact. So I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
Now, I think the first time you said fired in and then you said fired from.
The reason I just say in is that cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical.
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value from microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received 1 t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was unable to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is States 2. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
And I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Very briefly, so Mr. Hausdorf, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Leroy,
No, sir. Thank you.
can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you. State,
Your Honor, at this time, the state rests.
all right. Members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics you've heard anything about. Don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes.
Well, that was quick. They've rested. I can think she's very nervous at the minute. I'd be shitting a brick right now. So here we go. State has rested. Wow.
All right, you all can have a seat. All right, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, I want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm looking back through my notes. We've still got the issue of Vicky Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss? The expert.
Ferris.
Ferris, Ron.
I don't know where I got Bliss.
He's a police
You
officer.
smushed them together.
Okay. We've got that. And I have another Richardson issue. It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own
To impeach.
her own explanation for them.
Yes.
Which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And there's one other matter.
Oh, all right.
In an effort to protect Miss Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday. So I've already heard from Miss Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
by Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So, I was going to kind of give you all the option. If you want to, I can give you the break that I'm giving them. You all can talk about, do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay.
Yeah.
All right.
I think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now, I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just want to clarify.
Sorry.
Thank you.
Well, yeah, I think let's at least get that done this evening.
Yes, okay. That was gonna be, I was trying to figure out if you meant JOA or JA.
Yes, I'm sorry.
So now,
That's the reason why breaking early is probably good.
right. So let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do. And then we can hit the ground running tomorrow morning. Just so you know, because as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, a 33-day motion. I'll have to hear first thing if it hasn't been obviated by the filing of the information or a null pros. I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
Interesting. All right. What I missed that. I've got to go back a second because I missed something there. I'm not sure if anyone else caught it. They filed another.
Breaking early is probably good.
Hang on.
All the way through this.
Already heard from Ms. Floyd, because we've yet to deal with this. I issued another subpoena to the JA yesterday, so I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
by Ms. Brown's testimony.
What, Miss Floyd? What? Let me go back a little bit more.
To impeach.
Her own explanation for them,
Yes.
which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And there's one other matter.
Oh, all right.
In an effort to protect Ms. Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday, so I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well,
Miss Floyd.
I guess we'll eventually just kind of wait and see if her presence is obviated by
Yes, sir.
by Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So
I don't know who Miss Floyd is. Who's Miss Floyd, people? Do we know? Because I literally thought it was Miss Murphy. Miss Floyd. Ooh, I wonder who that is then. Let me just go here. Yeah, I have no idea who that is then. Miss Floyd. No idea who it is. I was hoping somebody might know, but obviously not. Or if you do, no one's saying anything anyway. Mama Ames, I'm saying, who's Miss Floyd? Interesting. Is the camera actually coming from behind the judge's left ear?
Items,
I don't. Oh, you want to see the judge then? Hang on. Because we can't see anything there. No, his left ear is there. Not that I can see. Yeah, motions to quash the sanction. I don't know what it means. Who's Miss Floyd? Because I thought it was Miss Murphy, the attorney, but it's not. Miss Floyd. And the one that's going to come in is Miss Brown. So, interesting. Interesting. Yeah, I mean, just to hear this. JOA now, just, yeah, I mean, he's never going to dismiss it. So, right, hang on, let's have a look here. Oh, darling. Oh, para 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 para. Right. Bucky. Right. I know the defense wants to impeach Murphy. I wonder if it has something to do with it. I think it does, but who's Miss Floyd, Deb? That's my question. Who's Miss Floyd? Pink Floyd's mother, Toots. Zach, is this because she doesn't want to get on? Where's Zach? Because she doesn't want to get on the stand. I mean, the only way to truly know is to ask her, have her testify. I don't, people, I'll be honest with you, I don't think the prosecution have proven anything. I don't think they've proven anything. Now, another song in my head, still on the like and subscribe since this morning, non-stop. Press the like, press the like, press the like now. Press the likes and subscribe. Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. Sorry, Jessica, because you mentioned it, I had to play it again. I think mostly. I think we got lots of likes today, which is good. We got 129 likes, and we only got 70 here, so or 70 plus here. So yeah, press the like, press the like, press the like. Agree, days. I don't think they've proven it. I mean, I know some people. Like the poll says, 43% of you say that you're either leaning or you are guilty towards her. And then 57% say not guilty. So it's leaning a little bit more towards not guilty than guilty. Yeah, I mean, I've got to be honest. I'm not sure how they're going to. The main part here is going to be the charging documents. What are the chart? As in, what I mean by that is, what do they have to tick up? What does the jury have to tick a box about? You know, what do they have to tick the box to go? Oh, yeah, they've proven that. They've proven that. They've proven that. So when I say the DA, I don't believe have proven it. I don't actually know what they're supposed to prove yet. That'll all come out in the jury instructions. So I suppose, you know, we should wait for that really. But I would be a little bit puzzled if I was a jury right now, because it's not in the question whether she shot him. She's admitted to that. It's whether self-defense or not. I don't know. I love it. Oh, thank you, Jess. I think they've pushed her onto the defense to prove she was scared and involved in domestic violence, but that's not their job. No, it's not their job. The defense could rest, I think, right now and be like, prove it. But again, it comes back to what the jury instructions is. Just don't you with the MA shirt. Yeah, the mask shirt. Peabody, Worcester, Oxford, Pembroke, Swansea, Oklahoma. No, Oklahoma, Peabody, Fire. What's that? Fall River. Looks great on you. Thank you, Care. I did press a like. Thank you, Christine. Just stream a double good popcorn. Happy days, Lisa. I wish they delivered to the UK. They don't. Bastards. I wish they did, though. I'd buy a ton. I love popcorn. I feel like they haven't proven anything either so far. I'm still not 100%, but I love the judge. There you go. Exactly. Do we have the charge documents? No. It probably got somewhere. It's just the charge documents don't bother me. It's the jury instructions I want to hear now. What are they being tasked with? You know, that's what I want to see. So I reserve full judgment until we see what they got to agree to, I guess. My mind changed when her mum said, she never mentioned him abusing her or Emerson. So your mind changed to guilty. Or, you know, I not to dispute you, be devil's advocate. Like, if you were being abused, would you tell your mother? Like, I mean, you may well do. I have no idea. Or would you? I don't know. I think that if I was abused by a lady, I don't think I would tell her. But just being devil's advocate there, you're entitled to your opinions, don't cut, and I respect you. Are you doing the Brian Walsh case? If you're doing the trial, the judge is on the one that did the kind of reach. Yes, it is the same judge. You're right. Yeah. We'll see. We'll see. We'll see. DC Plymouth. No, not right now. It's upside down. I need to take my top off. But hey, I don't. Hey, ladies, calm me tits. Yeah, calm me tits. I'm not going to strip off. Yeah, not going to strip off here. You just had a shower after Trigos. So some of you. Can you imagine if I just whipped it out now and say, hey, so here's Plymouth. Get my man boobs out. We don't need that this time of day. Any news on the double good situation? I heard they had backtracked again. Double good? What's that? I'm not sure what that means. Also, all TV victims say nothing about their abuse. Yeah, I do not portray that I understand anything, so I'm very careful not to judge DV victims. I am not one myself, so I don't know what they go through. So yeah. No, it's not over for the day, Jung. Amy, we got two Amy's in the chat. We got Amy Lynch, or we got Amy in Boston. Yes, guilty-ish. Now, the ish part, Stormcat, means that she's not guilty. She needs to be guilty beyond a reasonable doubt. If there's an ish in there, that means not guilty, in my opinion. What vibes do you get from her? I feel like I'm watching Lifetime watching her. I'm watching Lifetime watching her. I don't know why. I don't know. I mean, obviously, I'm a man, so I look at her and go, you know, no, I don't really. But do you know what I mean? I don't know. It's hard to judge. Is she being manipulative? Or is she being genuine? I don't know. I don't know. Hell yes, I would. Stalker. Lot don't tell anyone as they ashamed. Yeah. Well, it's right before Cape Cod. Cape Cod's down here somewhere, isn't it? I'd be dizzy, Toots. I'd be dizzy if I looked at it. I have seen it before, though. It's not all for the day. We're coming back in a second. Nick said they unfroze the account and allowed to. Oh shit! Sorry that. Yes. Sorry, I should have said. Mazza Media announced it. It's unfrozen. There's more popcorn on the way, people. Spread your legs, everyone. I agree, Dylan. Pretty flimsy so far. I'm not convinced it wasn't self-defense. There you go. And this is coming from West Virginia. Mountain Mama. Da, 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 da. It's the wrong platform for that. It is. I need OnlyFans. I do sometimes get my tits out, so careful. Calm your tits, people. I never told my mum, really. I wouldn't come right out and say it, but she knew, and it killed her heart. I can imagine. How can you prove no DV? Johnny's team proved it when they crossed Amber, but if you think about it, it's really hard to prove no DV as you document it. Mother said no, didn't she? They prove. I don't profess to know. I just don't think that. I don't know, Jen. Good questions. We call those moves. Yeah, I got moves. I got moves, and I got moves, Amy. I get that completely. There you go. No still commit DV around witnesses. True story. Mama Ames. I've been involved in DV and I see in her that she's manipulative. Yeah. This is again, we've all got arseholes, yeah? And we've all got opinions. And what opinions? Opinions are like arseholes. We've all got one. So absolutely. Lady shake a movies. Woohoo! Let's go, ladies. There you go. I have these. I might hurt someone. That's great news for the car and the popcorn. Yeah, it is good news. It's stupid because they get 50% as a fundraisers, but it's because of the anti-Karen Reid people complaining about it. Just sad people. So the prosecution proves she has that kind of character. Yes. Yeah. Move your moves. I can. Oh, smack. Haha. I got my dad's genes on boobs, not my mum's. Ah. There you go. We love it. Boobs, tits, whatever. Calm your tits, everyone. Calm your tits. It is interesting. It's an interesting case, I think. I was expecting more, if I'm being honest. I was expecting more. And I know there's a lot more stuff out there that people will say, oh, well, but the daughter said this, the daughter said that. We've heard this in the pre-trial stuff and stuff. But like going by just the evidence we've heard today, I can't. Yeah, I need to. Sorry, I'm just going to go. I've just seen your post there, Lepardo. I haven't seen Sean's post. Oh, where is it? Where is the post? Is it on X or is it on Facebook? Would be go through the motions, yeah. Oh, okay, I got you. Let's share it, shall we? YouTube. Oh, I got it on Facebook. Moves, I know. Oh, they're back. I can't put it up now. No.
So.
Yes, sir.
It's never easy, Your Honor. We have a witness issue. Faith Brown is available now, but she is not available tomorrow. She will not be a long witness. One which the court would entertain. However Your Honor wants to do it, while we have the jury here, I can call her. Or case law even says the Supreme Court case of State v. Smith, the court could call her as a court witness. And when she's done, then we could do the JOA or we could do it reverse.
I'm sorry, did you say she's here?
She may be outside now. She was on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't know about her.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before, not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state. That's the other subject of your
Yes, it
Richardson
is actually.
hearing, is those emails from the sealed hearing that we've now had access to. I think it had to have been obtained by the defense from Ms. Faith, whatever.
Faith Brown.
Faith Brown, and because the state's never gotten this until yesterday.
What was the date, September 30th?
Judge, those emails came from the state.
You're gonna have to show me where, because I don't look in my.
Well, hold on, we don't need the back and forth. I'm trying to figure out.
I don't know how we have access to this.
Listen, this is for me, who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be outstanding up here.
My first one of the trial.
No, that really would work out pretty well because I got witnesses like planes stacked and my head is spinning over it. So yeah, that would.
And just so you know, State, this is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of hit reset, and then defense, you can come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors, I can't remember.
No.
There were conflicts that started next week.
But I don't know
I'm not sure what they were.
started Monday or Wednesday or.
I think the juror that, the gentleman we had last today, he had the conference starting Monday out of town. Not that we would be done tomorrow anyways, but.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
Right, but does that mean finish Monday or finish Tuesday?
Oh, definitely.
Define finish.
Definitely don't finish Monday.
All right, so defense case done Monday. And then
we
you,
close Tuesday.
and then you,
That'd be the-
I think that might be optimistic. I think Wednesday probably is more realistic.
just
right,
saying.
so finish defense case Monday, but then we have jury instructions.
Right.
Oh, can't. I apologize, sir.
Okay.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
Yes, I mean, you're correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
right,
we can try to finish the case up Tuesday, if it's not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I don't make the final decision, but that would be my opinion, is to not go a full day without doing any trial tomorrow, but.
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Just one.
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information was filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock. And then we start the defense's case in chief around 1. And go as far as we can. Okay?
Okay.
You're nodding your heads, but
Yes, sorry.
Okay. All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with the goal of having them up here around 1 o'clock.
All right, so I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
On Monday.
Well, if she's not available tomorrow,
She's not. Is she available Monday? No, she's out.
I'd say maybe call her Monday.
Yeah, that'd be fine. I can
Mr.
do
Harris,
it.
she's not available.
I just want to make sure she's available.
Sure.
Yeah.
Right, is she under subpoena?
No.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed, seems outrageous.
No, hold on.
Okay.
This is me, because I want to get these, I got a bunch of hearings that I got to get done, including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done. Did he step out to ask? What's he asking?
Want me to bring her in?
No, I just need to know, is that the plan?
Yeah.
So, because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we could put her on today, then
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
okay. Can you give me a moment?
Of course.
So there's a lot of stuff to do, obviously, right now. I think in some ways the state have rested a lot earlier than maybe anticipated a little bit. Oh, so that's why I think they're trying to finish it a little bit earlier today, get everything in and decompress. Yeah, the DA is a little bit, just needs to pipe down a little bit. Oh, Miss Floyd's a judicial assistant. I thought it was Miss Brown. Okay. I know. Laura, hi. Hey, did you have a shower after Trigos? What did... I don't know what beautiful inappropriate did here. It's love, not perv, just saying. What? Don't mind me, I'll put my tea. What? Oh, with a song, okay. Okay, I'm just trying to check here. Miss Brown was Ashley's original lawyer. Okay. Okay, so yeah, I think you're right then. Crime junkie. I think you're right. Miss Floyd is a judicial assistant. So yeah, so I was just trying to look if I could find the witness list, but I can't. So it looks like they're going to do tomorrow. It's probably rest on Tuesday then rebuttals maybe Wednesday, jury instructions. I think we're probably closings. We're probably looking at Thursday to finish this trial and to get a verdict, I imagine. I don't think a verdict's going to take that long, especially with 6 people. So I think we probably get a verdict if they do closing statements on Thursday morning. I suspect in the afternoon we'll probably get about 4 hours of deliberation max and a verdict. Everyone's stressed out because you went missing, Erin. You went missing, and so everyone got stressed out then. Like, I can understand why Ashley is stressed out because she's obviously looking like Young was saying about Sean had said that they might introduce manslaughter. If they do, pieces of shit, because that's up to 30 years in prison as well. And I think if they bring in manslaughter, then they might compromise on the manslaughter, which sucks. I just don't like it when people do that, when attorneys, the DA office do that. I think if in my opinion, I know they won't do it. In my opinion, if you introduce manslaughter as a lesser included, then you should take murder off the table. You shouldn't be able to just add different charges in my opinion. Just to hedge your bets, bastards. I hate it. Where the hell is this attorney gone? Has he gone over to her and said, all right, spread your legs or something? At least we're finishing early today. That is one good thing. But we'll be back tomorrow, same time as usual, 8:30 Eastern, 1:30 UK time. Obviously, the judge has to agree to the lesser included as well. So we'll see if he does agree to it. So at the minute, if she gets charged for murder and gets found guilty, it's a minimum of 25 years to life she's facing. And if she does get manslaughter and found guilty of manslaughter, if it's introduced, that's, I believe, a minimum up to 30 years. I don't think there's a minimum. I think it's up to 30 years in prison.
I'm happy to report, Your Honor, she will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
So we're gonna do all the motions this afternoon?
Yeah.
Thank you, Judge.
Yep. And hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
Yes.
But while you're doing that, can one of you stay?
Yes,
And I'm going to tell the jury 12:45 tomorrow? Well, no, wait a minute.
Right, now we have to have them here in the morning.
Now I need them here in the morning.
Yes.
Okay, all right.
What a disaster. So, actually, we're not finishing early. We're carrying on.
Hold on. I just want to make sure she's going to be available. Because you guys have every right and should be able to speak with her about her expected testimony. Did that come up during your conversations?
It might come up, but I'm sure she'll talk to the judge.
Go ahead.
Well, Your Honor, I feel like a vacation has been snatched away from me.
The what?
I feel like a vacation has been snatched away from me. I was picturing having to go on a walk.
Can't believe he fell asleep. The state arrested and there's a mess now. We've got some hearings to do this afternoon, which we thought we were going to do tomorrow, but no, we're doing today now. Wayne, I think you need to refresh. There's more than that. There's 136 likes. Yes, they did. The defense believe they're going to need about 2.5 days for defendants. So I think we'll have a verdict on Thursday, is my guess. Maybe Wednesday, but not Thursday probably. Ooh, tattoo. Erin Hakakakuli. The white noise from the court bugging me. Ole, 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 ole. Ole, 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 ole. Erin Hakakak. Erin Hakakak. Ole. Oops, right. They might be back. Oh, now it's a problem again. He's talking to the attorney. Good help isn't cheap, and cheap help isn't good. No, that's right. Uh-oh, there's a problem.
Okay. Is she out there? Okay. Judge. It's never easy. We have a small complication. It's an issue that Your Honor's going to have to deal with. She was not under subpoena by either side, and was not told that because she wasn't expecting to be witness, that she could not observe the proceedings. So she has watched some of the proceedings. Once I contacted her, told her that we needed her, we've told her to stop, and of course she's conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now. I'm just,
Okay.
you're on notice. We're just waiting for her, Miss O'Donnell, to come back in and confirm that we can get, you guys can speak with her tonight or tomorrow. Yeah, just, I need to know that answer so then I can decide, I can let the jury go. Because if you can't speak with her tonight, that'll be a whole other issue. Or depose her in the morning, one or the other.
Okay.
Hi, Chicken Palm. How we doing? It's a little bit funny. I don't know what's going on. The judge seems pissed. So we'll see what he does. 'Cause I don't know. I don't know why. Don't know why Erin Hack's here. Normally I get so much done on my days off. I gotta go vacuum or something. Erin can't rest. He can't rest. Erin Hack, she can't rest. She's like a Duracell bunny. Right, are they back?
Miss O'Donnell is back. Is she going to be available for you to speak with her this evening or tomorrow morning?
I spoke with her. We did not set up a time, but I think she will be available when I need to speak to her again.
Okay, all right, great. So I'm going to tell the jury to be here Tomorrow morning, 8:45, start at 9.
Sorry, Judge, I didn't realize you needed me to come back.
No, it's fine. Don't worry about it. Yes, bring him in.
No, I've not watched the show, but I've heard all about it. I will watch it. I don't know. I'm not sure if he's deleted the chat. I don't know. I don't know. I don't know, Amy. Care. Years. Why does everything have to be so confusing? I know. Those really mean teas. They've probably been day and night for weeks on end. Sorry. Hey, Denise. I've been watching while working done. Happy days. Nice to see you, darling. Fairyland Acres. Stone Show as well. Yeah, I've heard about it. I need to watch it. I need to watch it.
All right, y'all can have a seat. Welcome back, everybody. I know what you're thinking, that was longer than 15 minutes. But, okay, so there are some things that we need to do on our end. And the reason I gave you that break was to have a conversation with the attorneys and kind of make a list of everything that we need to do before we can move on to the next step. So what I'm going to do is we're going to stay this evening and keep working, but I'm going to let you all go for the evening. So remember, please don't discuss amongst yourselves anything about the case or begin deliberations. Don't talk with anybody outside of the jury about the case. And please don't do any research on people, places, things, or legal topics you've heard anything about. Tomorrow, if I could have you downstairs in the jury assembly room at 8:45, and we're going to have a goal to start up here about 9 o'clock. Figure if we stay late, and then some things tomorrow morning, we should be ready to get going then, okay?
Yes, sir. Okay, thank you.
All right, thank you. Just fold up your notes and leave them right there on your chair.
Right.
And we'll see you tomorrow. Good night. Okay, y'all can have a seat. All right, the state having rested defense, your JOA.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Miss Benefield immediately fled next door to call 911. And 911, of course, is what you do to summon help. And there has been nothing indicated otherwise that Miss Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Miss Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is he attacked me and I shot him. There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield. And if they are properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden. The self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintal, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this: 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where is there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State?
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind, regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there is also spite or evil intent. And that is disjunctive, so it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time. And she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said that this was the same exact judge that she had not had luck with before. And implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side. So he was turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together In the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA.
Thank you. Mr. Taylor, would you like to place any rebuttal in the record?
Very briefly, thank you.
Or not briefly?
Yep, no, briefly. So here's what we have according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Berger, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance is what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed and failed miserably to rebut it. And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right. Thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
No. Okay. All right. I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by a preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. You're going to see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson. You're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it, I might be mixing apples and oranges. Something was 390 and something was 316. And
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked and he showed me the part that was missing. And based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an
The auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said, I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. But the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies or at least clue me into where it is and what exact pages are intended to be entered. And that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
Do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense And I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at a trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of a doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony. That can't be right either. So we have to find the happy medium here somehow, understanding and appreciating that we were on guard for this development months ago. And that was why we issued the subpoena to the JA. But I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said on page 4, I have an envelope to seal this. If necessary, I have Ms. Murphy's stand your ground testimony that I will pass to the court.
You might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking. That was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, was he turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about Vicky Mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Miss Murphy and Miss Brown as meaning different things? Could it be received by the jury to be substantial in their decision making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was documents, we could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice. and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently. But I just, at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Faith Brown because she was not listed.
Yes. Okay. Do you want to be heard on that?
Can we just have a minute? We were just
Of course.
discussing. Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that along with these emails, it feels a lot like sandbagging to the state or trial by ambush, as I think your judge, as your honor called it. And that was our concern. But in the light most favorable, in our mind, to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed or they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
Now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed,
Yes.
I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing on calling of Ms. Brown.
Yes, yes.
So hold off on mechanic subpoena for now. The argument about it.
Yes,
Okay.
I
well,
think so.
I'm just going to put that on the back burner for now. And
I suspect that's going to be resolved.
we still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying. I typically will do this in a trial. I'll do it early on, but I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
Skip that.
respectfully.
Fair enough. No, let me look. I don't think it does. All right. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions they'll be asking. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended. I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart. And I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney. And this is just piling the pressure on the client. I'm sorry, Your Honor. I find it uncomfortable.
You wouldn't be heard for the record. I mean, it's my decision.
I would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say. And if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So if you say, hey, don't answer that, okay. But I'm going to have it on the record because in the future, if anybody says, "Oh, I didn't know. I thought I couldn't testify. My lawyer told me no." I mean, the plethora of cases that are out there. I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask, make sure that nobody's threatened you, forced you, or coerced you to make this decision. That nobody's promised you anything, any benefit or a particular outcome to make this decision. That you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it. And if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it. And then we'll have that conversation either tomorrow or next week. All right. Anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right. Well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course. Absolutely.
Oh, I don't know what's going on now. This is exciting. Oh, I'm so excited. Ooh, I just can't hide it. Ooh, what's going on? I be honest, like, I'm not saying I agree with everything the judge has done, right? But I do like the judge. The judge has got such a thankless task. Like, such a thankless task. So it's really hard to find a good, fair judge. And I do think he's good and fair. Hello, Ruka. How are you doing, darling? Oh, so let's hear what's going on. These two bitches. I mean, when he was doing the acquittal speech, who the fuck's starting the? Hey, who's this? Hang on. Who's this? Oops, wrong one. Oh, you mother. Hang on. Indulge me for a second here. Indulge me for a second. Right, here we go. Who's this? Not seen her before. Just so you can all see it. Who's that? I don't know who that is. Just spotted her. Hey, Tommy's next to her somewhere. Tommy be like, hey, darling, how's it going? How's it going, love? All right, let me go back to here. Right, bin that. Yeah, these two grumpy fucks. They were like laughing, giggling. I don't like that. Don't like that. But anyway, let's get back to it. Let's get this on here. Oh, hold on. Let me go back a second. Here they are.
All right, Judge White, we're good. Request withdrawn.
Okay. All right. Anything else we can talk about today? No?
What time will we start tomorrow? 9, she's been back.
Where'd my list go? Let's shoot for 8:45, just in case there's any last minute stuff. And then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so. Right, we're gonna have them lined up one after another, ready to go?
Pretty much.
Okay.
Thank you, Munchie.
All right, we'll be there off the record until tomorrow morning.
Thank you, guys.
Thank you, Munchie. I appreciate it. Hi, Delan. I just started to watch this trial on your page. I also have to add, I love it when you just start singing. Thank you, thank you. Thank you very much, Munchie. Where are you from, Munchie? Are you from the States? Whereabouts in the States are you from, if you're from the States? Or whereabouts in the UK are you from, if not? The girl from Mario. Who the hell is she? Hey, spot time. I had a perv, eh? What request was drawn? No idea. Don't know. It's something that they brought up to the judge behind the scenes. So it's not public knowledge. So we don't know. We don't know. It's too much. You've been sleeping all day. Do you know what? It's been nice and peaceful in chat today. You've been sleeping most of it. Right. Let's see what she does. Does she go to hug anybody? Let's see. Because you guys think she's got a boyfriend. I don't know if she has. So I want to see if she goes to hugs anybody. Oh, from Mass. From Worcester. Park the car. Park the car in Harvard Yard. Then go down to Worcester. Nice to meet you, Munchie. Thanks for being here. Yeah, Worcester is his hometown. You're right. Right, hang on. All right, where she go? Oh, where's she going? Where's she going? Oh! Oh, there's a big smile on her face. That was a big smile on her face there. Temu Trigos. Do you reckon she goes home one night and goes to him like, the judge just told me I need to spread my legs? Whoop! She must be flexible as well. Bloody hell. He reminds me of somebody, that guy does, though. Not Trigos, but he reminds me of something. He reminds me of somebody. I don't know who, though. Not Trigos, somebody else. I can't put my finger on it. Right. We are back tomorrow, people. Oh. Yeah, she sings, you know, when you put your hands up in the air, she's like, put your legs up in the air, spread them like you just don't care. That's the judge's song. Put your legs up in the air, spread them like you just don't care. Ooh, ooh, ooh. That's what the judge sings all the time. If people don't know, the judge did say yesterday, he told all the jury, remember to go to the back and spread your legs instead of saying, you know, whatever he said, whatever he's supposed to say. He basically said, jury, go and spread your legs. So just in case people thinking, what the fuck you on about? They are witnesses. Stretch. Yeah, stretch your legs. He's supposed to say, but he said, spread your legs instead. There are witnesses tomorrow. Yes, Christine, there are witnesses tomorrow, starting at 9 o'clock. He's trying to be Trigos, hence the temple part. Okay, I'm with you. What the hell, Amy? Hopefully that explanation explains to you what I mean, Amy, by that, just in case. I'm not a dirty old man. It's just a joke. Hope everyone has a wonderful evening. Yes, see you tomorrow, people. Far and me, stretch, haha, stretch. Have a good one. How to get ready for the red? Oh, you got red hot chili peppers. Nice. Happy days. Oops. Thank you, Yaya Trucker. Thank you very much. Yeah, sorry, you people. Yeah, I should explain. Obviously, that was a joke before people think it's based on what the judge said. It's a joke before anyone starts. Spread your legs. Yes, judge is naughty, not me. Have a great evening, everyone. See you tomorrow, everybody. Judge did say spread. He did. Go have a good stretch. That's it. Go and have a stretch, ladies. Have fun. Right, everybody. I will love you and leave you on that. So I'll be live again at 8:30 Eastern. Oh shit. That's gone limp. 8:30 Eastern, 1:30 UK time. The shoe fits. Good night, Josie. Good night, everybody. It's been fun. It's been all right today. Good night to you, Mama Ames. Right, I'm going to play the outro for you guys. Good night, Munchie. Thank you, Munchie. Thank you, Munchie. Please chat away as well, Munchie. Chat away. Night, night. See you, Zach. See you, Rehab. See you, Patty. Sounds like a personal problem. Here we go, Erin. Life story by Erin. Have fun. That was funny. There you go. Thank you, Josie. Good night, mediocre chicken palm. Stormcat, good night. And anyone new that was offended, it's a joke, people. Not that I'm going to apologize anymore. Most of you know it's a joke, so it's fine. Right, here we go. Let's get the brand out. Let's get it going. Let's get it on. Let's get those legs on. Right, everybody, take care. Peace out. See you tomorrow. Ta-ra.
That's